Good morning and welcome to the second day of the hearing into the appeal in relation to the application under Section 75A of the Town and Country Planning Scotland Act 1997 in relation to land at Deanburn Road in Linlithgow. The hearing in this session started yesterday and hopefully will continue to completion today. My intention is to put it on a similar basis in terms of timings and organisation for today, and that is take a break. Intended to be around 11:30 this morning for 10 minutes and break at 1 o'clock, and then we can make a judgment in the afternoon as to when we start and when we finish, depending how much progress we've made in relation to the outstanding issues. Although again, I would emphasise, as I did yesterday, if anybody needs a break for any reason at any time, just say, and that can hopefully be accommodated. By way of just one introductory point before we get into proceedings for this morning, taking up where we left off yesterday, we received an email quite late last night. Mr. McLeod's obviously working late. I think it was around 10:37 email to the parties in relation to the point that was raised yesterday in connection with the powers and options that would arise in the event that a different modification were in mind. And while Mr. McLeod and the council themselves would reserve their position, that's not the primary position in relation to this appeal. That email has been submitted, and I understand before you came on, Mr. McLeod, certainly Mr. Alexander has seen that and has been able to access that. Subject to one caveat, I'm very happy to hear any representations the parties want to make in relation to that email, either to amplify it or complement it from Mr. McLeod or to comment from any others this morning. Very happy for people to do that. But equally, I'm content if parties are that any further representations in relation to what's come in last night, which is very clear in its terms and contains a link to the case that Mr. McLeod referred to yesterday, are included in closing submissions when we get to that stage. It obviously is a bit dependent on the evidence we're yet to hear this morning as well, for the reasons Mr. McLeod has alluded to. So I'm perfectly content to allow parties to come back on this in closing submissions. The one caveat is obviously the email was copied to you and Alexander on behalf of CALA. They're not here today. As an interested party, they may or may not be wanting to make closing submissions generally in relation to this matter. And what I was inclined to do is apply the same approach to them if they're wanting to make submissions, that anything in relation to that matter can be included in those submissions. But if they were not otherwise intending to make closing submissions, to give them an opportunity within the same time frame to make any representations, if so advised and as they think fit, on Mr. McLeod's email that was received last night. And if parties present on this call are agreeable to that, I'll ask my case officer to write out today, just confirming that to parties, and in particular to you and Alexander, if that's what the agents for CALA are minded to do. So that's my procedural suggestion of how we deal with things. But I'll move first to Mr. McLeod for any comments, anything he may want to add in amplification of his email last night or on that procedural suggestion.
I'm content with that, sir. And really, just for anybody that hasn't had a chance to see it, the point is it deals with the issue of how the reporter could deal with a scenario where he thinks that a different contribution should be required rather than the appellant's position, which is that no contribution should be required. So in essence, it's an example of another appeal decision where a reporter found herself in that situation, albeit different factual circumstances. And the way that she dealt with it, she issued a notice of intention to the parties saying, this is what I'm thinking about doing, let me know your position, and I'll then reconsider what to do next. So that's the general summary of it, and I don't really have anything more to say about it other than, as you've noted, sir, our primary position is that issue should simply not arise on the basis of the evidence that's before you.
That's understood. Thank you. Mr. Alexander?
Yeah, thank you, sir. I'm not sure it would really require a great deal of submissions on the point, having looked at it and looking back to our hearing statement at 1.7, that really covers the council's position. That is open to do that to you, but of course you need the appellant's consent. And an obvious way of doing that would be a way that Ms. Kratz did in that decision in terms of effectively issuing a notice of intention. So I don't see it as, given what's set out in the legislation, I think it's quite clear, certainly from my point of view.
Thank you. Dr. Kelly, how much of an interest you have on this particular point, or what you may want to say? You can maybe explain yourself, but is there anything you want to say on this particular point? I appreciate, again, you'll only have had the opportunity either late last night, if you were on your email late, or this morning to have looked at that. But just in terms of the kind of procedural processy ways in which we take this forward, is there anything that you want to say to me?
I'm quite happy to leave it to a final submission. Our position is, I think, pretty clear. We're looking for a resolution to the problem of the High Street, and the means to do that. So I would leave that until a written submission following the hearing. Thank you.
Thank you. That's very clear. Okay, right. I think we got to the completion effectively of point 2.7 on the agenda yesterday. Point 2.8 is the question about whether planning permission would have been granted if Carla hadn't agreed the transport contribution. In effect, I think we covered virtually all of those points yesterday. What I just wanted to say in relation to that is to nod in the direction of what the council said to me. They quite correctly pointed out that, in fact, any suggestion of the possibility of planning permission not being granted, all they can speak for are the planning officials' recommendations. You quite rightly summed up the fact that elected members act on the basis of recommendations to them, but of course it's their decision at the end of the day. So standing that clarification of that position, I was grateful for the representations made, that the view expressed is the view of planning officials, and it's subject to the planning committee ultimate decision on that. I wasn't particularly looking for further representation or any other aspects on paragraph 2.8 apart from just making that clarificatory point there. But I don't know whether, first of all, I see Barry's got her hand up, whether you want to make any point in that respect or on any other aspect of this issue, and then Mr. McCorriston.
Good morning, sir. Thank you. My point was a separate point in relation to discussions that took place yesterday. The council would appreciate the opportunity at some point today to clarify a couple of points discussed yesterday relating to the suggestion that the council's interventions would worsen the position in Linlithgow Town Centre. In terms of when this happens, we would be happy to pick this up now or at some point later in the day, depending on what your view is. I think it'll maybe take about 5 or 10 minutes.
Okay, I'll go to Mr. McCorriston first of all, if we see his hand up as well.
Yeah, good morning again, sir. It was really a similar point to Ms. Foy's point there. You had asked me yesterday if I could provide some clarification on the value that would be indexed,
Yes.
the value that would be invoiced if an invoice was to be issued today. We've done some work on that, and I'll be happy to provide that clarification to you either now or similar to what Ms. Foy said, at a point that's convenient to you during the day. And the second point of my hand there was to say, yeah, I agree with your summation of point. Sorry, where are we in the agenda? Whether the recommendation to committee would have been, sorry, whether planning permission would have been granted. You're absolutely right that would have been a decision for committee, but for absolute clarity, I would not have recommended to committee that it granted planning permission had I not have received the letter from Carla, which has been submitted to you.
Right, thank you. That's pretty clear from that point of view. I was going to just maybe go to Mr. McLeod next to finish off the point on issue 2.8. If there is anything further he wants to say, then go to Vary Foy and ask her to do the updates now, just before we start on today's business to finalise yesterday's. But is there anything, Mr. McLeod, you want to say on paragraph 2.8, since that's where I was starting from?
No, thank you.
Okay, then can we just go to Vary Foy and just, if you can maybe just indicate the updates or clarifications you want to refer to from yesterday's evidence.
Thank you, sir. Yesterday there was discussion of appellant's document A008, which is the supplementary guidance, and the annexed sister report.
Yes.
And there was a suggestion that with reference to table 11 of that report, that the council's proposed interventions would make matters worse. This position is not accepted, as if reference made to the table, it shows that the scenarios, including the west facing slips and mitigation, show improvements in network performance over the do nothing scenario. And that can all be read if you look along. If you look on table 11, it might help to have it in front of you.
Yeah, just bear with me a second. I'll get that, because that's my next question. I think it was clear that the council disagreed with that, but if you bear with me a second. Okay, and table 11. I have to zoom down from here. That's in about page 32 or some such.
Yeah, so page 33.
33. Okay.
And
again, just hold on for a second, because we've got too many documents open, but the things are a wee bit slow opening up. Bear with me trying to get to that until it all opens. Yes, page 33, got you.
yes, so in the row, the second from the bottom, that talks about the totals.
Yes.
Under the do nothing scenario, there is a 15% delay, which is worse than any of the other figures along that row. And I'll pass now to the council's transport witness, Victoria, to explain in more detail why the proposed interventions show an improvement over this do nothing scenario.
Okay, thank you.
Good morning, everyone. So I'll just start by clarifying. Yesterday it was mentioned that the sister report was prepared using parametrics modelling. Just for clarification, it was actually based on VISM modelling, the difference being that parametrics uses delay times and the VISM modelling uses journey times. So for the purposes of this discussion, we could look at either table, but we'll look at table 11 because I know that's the one that Mary's just mentioned. So within the totals column at the bottom, the figure sits at 15%, and that's based on a base figure of 4,252 vehicles. If we then jump along to column 9A for full development demand with the western face slips, the percentage is down to 8%. That's a decrease of 5%, even though the volume of traffic has gone from 4,252 to 7,357. And that's an increase in 58%. The total figure under column 8A, the figure's sitting at 2%, and that's with the bonus traffic removed. And that's understandable because from the base figure, that would take us from 4,252 only to 6,669. So that's a distinct difference from the 7,357. So if we then look at column 9A, mitigated PM, that's with the western faced slips and the town centre improvements. The figure in the totals column there is 4%.
Yeah.
So that's a decrease of 11% from the base data. So although the figures have gone up in terms of the vehicle numbers from 4,252 to 7,357, you're still seeing a decrease there of 11%. I think yesterday, apologies, the point being that the figures were pulled out of the table, but the figures have to be read as a whole story from the base information. and not just the figures from the table itself, because it can be misleading.
Okay.
Thank you.
And the figures that you mentioned in absolute numbers, because I think you're referencing there on that table percentages, is it table 10 that has the, or where can I see the actual numbers that you?
It's table 6, sir.
Table 6. Okay, I can reference that. Okay.
Yeah.
Okay. So going back to Vary on that, I'm going to come to Mr. McLeod in a second. Is there anything further you want to say on that point, or is there a further point you want to make?
Thank you, sir. It was just to underline the point that that both interventions are required, the west facing slips and the Linlithgow Town Centre improvements are required to affect those improvements over the network. The other point to make when considering the sister report as a whole is to note at 2.1.7 that it states that introducing the west facing slip scenario affects around 90 to 140 trips in the peak hours, and effectively this scenario reroutes upwards of 200 vehicles an hour from Linlithgow Town Centre, Linlithgow High Street, sorry, for the full development scenario, which is the purpose of the council's interventions to remove traffic from the city centre.
Okay. Thank you. I see Mr. McConaghan's got his hand up first of all, and then Victoria Mungle.
Yeah, thank you, sir. It was just to re-emphasise that point that Ms. Foy has just made there in terms of paragraph 2.1.7. I mean, 200 vehicles per hour removed from the high street if the west-facing slips are put in. There can be no scenario where that can't improve the high street, and I do wonder if Mr. Snedden inadvertently made the council's point for it yesterday. I wonder if there was a misreading of the figures by Mr. Snedden, which is that if you don't put the slip roads in, there are scenarios where congestion on the high street gets worse if you do the mitigation. So if you do the mitigation at the junctions at either end of the high street without putting the west facing slips in, then there is an increase, that there is a potential for an increase in congestion on the high street. And so where you'll see that set out is, if you can just bear with me till I get the reference. It's in paragraph 5.7.4 of the SISTRA report, which explains the situation. And then I won't take you through the detail of the table which follows that paragraph, but that emphasises that if you do the interventions on the high street without the west facing slips, it adds significant traffic delays. I'd say the explanation is there in those paragraphs. I won't take you through it, but it does seem from the council, so that the position is absolutely clear that putting the motorway junction, the always junction in, doesn't make the situation worse, but it has to be a package of interventions, and that the interventions themselves don't work individually. Thank you.
While you've got the floor, do you want to give me your figures on the costings that you alluded to earlier on? I'll go to Victoria Mungle in a minute, since you have the
Well, so I'm absolutely happy to do that. It might take me 3 or 4 minutes to take you through that process. So I'm absolutely happy to do it at the moment, but I don't know whether you want to finish this bit.
Okay, well, let's finish this one. Go to Victoria Mungle and then we'll go to the appellants.
Apologies, sir. It was just to say that I'd referred you there to table 6, but I should have actually said table 7 for the B and the, yeah.
I think it's at table 7. Thank you, no problem. Okay, Mr. Snedden, do you want to come back on anything you've heard this morning in relation to the clarifications based on what you said yesterday?
Yeah, I do, sir. Yes, thank you. Yes. I think on table 11, I mean, I broadly accept the council's point that in some instances things aren't quite as bad as they are in other instances. But if you look at 582 of the sister report on page 29, and we looked at this yesterday, it clearly says there, red equals worse, yellow equals no change, and green equals better. And in fairness to myself, when I took you through table 11 yesterday, it did indicate that in the totals column, a row rather, there was a green scenario of -2%. But the point I made was that the other figures in that row are red, and by the sister report's own words, red equals worse. Now, it might be the case that some scenarios are less worse than others, but they're still worse.
Yeah.
So that is really the point. I haven't misread anything in relation to that. But I think as well, it's important to go back to the paragraph that was referred to there, 217. And this assertion that 90 to 140 trips in the peak hours and upwards of 200 vehicles are removed from the high street. Because on a, well, I don't want to say that the council might have misread this, although that's the accusation that was levelled at me, but if you read 216 for completeness, what that says is, on the introduction of the west-facing slips in N9 Junction 3, we have assumed that Sistra, the council's modelers, we have assumed that all trips which currently go from the east of Linlithgow to the west will now use the west-facing slips. Now, the model didn't do that. They assumed that. And if you go to page 11, sir, of the Sistra report, and just wait until everybody's got that to hand. That is the picture of the model that we were looking at yesterday.
Oh, yes.
Sorry, sir, do you have that now?
I'm getting down to it just now. I remember it from yesterday. I'm not quite there yet.
Page 11.
I think if you're using the PDF, sir, I think it'll be page 52 out of 80, if that's the document you're using.
Thank you. I'll get to it faster.
Yeah, my apologies, I forgot this document was appended to another one, so the PDF makes it long.
I think I've seen it twice, once appended and once not. Right, I've got that. I'm there now. Yes, we did this yesterday.
The big blue circle,
yeah,
in the dashed line. So what Sistra did is take the trips from all of the zones that are in that circle. So if we look in, for example, 7 on Blackness Road, that's one end of Springfield. 11 is the other end of Springfield. 9 is a house and access. I forget what it's called now. The same with 12. Anyway, all of the zones within the blue circle, what they assumed was that all of the trips that originate in that blue circle and leave the model at zone 1, which is the little red one on the other side. In other words, they travel all the way through the town, would in future use the west-facing slips. and that's where their 200 vehicles came from. So they manually reassigned these vehicles to the slips. And that ignores some pretty important points. So for example, if you live in Springfield or the new houses that have just been recently built on Blackness Road, and you have children at Linlithgow High School and you drop them at the school and then head west, there's no way that you're going to use the motorway to do that trip. In reality, what you'll do is go into the town centre network, to the high school, back down Preston Road, and then off to the west. So that 200 isn't 200, it's less than 200 for that reason. And others. In the evening peak, if you're coming home and you want to go and buy a macaroni cheese in Sainsbury's, then you'll similarly travel through the high street. You can't just take all of the trips in the east of the town and allocate them to the west-facing slips. And the problem with this, and I alluded to this yesterday, is that this model does not go far enough. The network is not large enough to allow vehicle choice within the model to do what it would do if it was presented with other alternative routes that have less journey times. And so the 200 is effectively just a figure that's been plucked out of thin air. And for the council to rely on that is pretty mind-boggling, to be honest.
One of the questions that came to my mind, Mr. Snedden, last night, when I was thinking about this, is the extent to which, if you look at certain junctions, we're supposed to think about St Ninian's Road, and you made some points in relation to that. There are some junctions where I think you said there was a potential worsening of queue times. I think that's what you said yesterday. Certain junctions, whether it was St Ninian's Road or not, I'm not certain. As one certainly was discussed. If there are negative figures in these tables, but nevertheless the overall benefit, the overall view of taking the figures as a whole gives a benefit, is that necessarily a reason not to adopt or accept the rationale of the SISTRA findings, that you can have an overall gain, even if there are some localized worsening of situations, or is that too simplistic a reading of how you would approach this sort of data as a whole?
So another again would be to be welcomed, but there's no clear evidence here of any overall gain. I mean, even going back to tables 10 and 11, if you turn to page 29 of the SISTRA report, and sorry, figure 12.
All right.
So figure 12 shows 6 routes on various alignments of traversing the wider town of Linlithgow, really. And data that's in tables 10 and 11 that's aggregated in the overall outcomes arises from journey times on these 6 routes. But none of these 6 routes are the high street in isolation. So you don't really know what the answer is for what happens in the high street. But what I would draw your attention to, and I'm now thinking perhaps selfishly about our own client, is just below that, 585. And what that says is introducing network mitigation shows that the mini roundabout at St Ninian's, this is the new mini roundabout, at St Ninian's Road High Street substantially improves the travel time on Route 2 southbound. Which is, I think your points are that there might be some overall benefit. But that paragraph goes on to say, this is at the expense of travel times on Preston northbound, where the weight of now released development traffic causes 162 seconds of additional delay.
Yeah.
So that's our traffic that's experiencing the 162 seconds of additional delay. So the proposition here is that we pay towards slip roads that we have an impact on of about 2 vehicles. And for the privilege, we have 162 seconds of additional delay on our own site. Doesn't seem to be the sort of thing that I'd be rushing out to buy.
Okay, thank you for that. Anything the Council Transport witnesses want to say in response to those effectively 2 points? There, one about the exaggeration of the number of trips because of alternative combined uses going to the high school or whatever, and that point about paragraph 5.85. The council want to talk about that.
Our witnesses are just having a conference there.
That's right, though. That's okay.
Just be a second.
So while
Yes, well, they're conferring.
Transport experts are dealing with that, I mean, I can make some comment from local knowledge. I mean, it's a modelling exercise, isn't it? It can be criticised or it can be received positively. It is a model of what is likely to happen. I suspect Mr. Snedden is right that some people from Springfield will take their car to drop the kids off at the school. That's something which we actively dissuade parents and carers from doing. And indeed, a big chunk of Springfield is beyond the statutory distance for school transport. So there is a school bus operates along Springfield Road in the morning going to Linlithgow High Street. Not all of Springfield Road is beyond the statutory distance, but pupils attending the school can access the bus service on a paid-for basis.
Yeah.
So there's a perfectly adequate bus service that takes pupils from Springfield Road to the secondary school. We can never get 100% of pupils to use that. We can never get 100% of parents and guardians to stop taking their children to school. But you know, a model in my understanding of it will never pick up these little human behaviours, I suppose, that go against the modelling. But there's absolutely no reason why anybody has to take a car from Springfield to Linlithgow Academy in the morning.
Another thing that strikes me about all of that, just before your transport witnesses come in, is, and this was alluded to yesterday, is that for right or wrong, and Dr. Kelly and the Planning Forum have ideas of how to address this issue. The difficulty, I guess, of going from one side of Linlithgow to the other is there aren't really alternatives. You've got a whopping great big palace and a loch on the way, and then you've got a canal and a railway station. So there are, again, I hate to use the word unique, there are some difficult challenges, I guess, in traffic management around what happens in the high street. When I think I've never forgotten which witness said this, but everything's channeled into the high street, and the high street serves a multi-dimensional purpose. Many high streets do, of course, but the fact that it's an arterial route through with tourist traffic and commercial traffic and residential traffic, I guess, does create additional problems from that point of view. That as at present, at least, there are few alternatives for people who, as Mr. Snedden says, if it so happens you're visiting your elderly mother at the other end of town, or you're dropping kids off at school or whatever, there isn't really a choice but to go through the high street. I don't know if the transport witnesses have conferred adequately to come back on Mr. Snedden's points.
Thank you, sir. I don't know that there's a whole much more that we can sort of add to that. I think that we can only go on the figures that's in front of us, and the figures demonstrate, based on the base data, the current numbers and the increased numbers, that the slips and the town centre improvements provide a benefit. I don't think that there's any debate on that. And I think that as Craig correctly pointed out there, some of what Mr. Snedden said was hypothetical in terms of how people take their kids to the schools. And without that evidence or data in front of us, it would make it very difficult for us to comment on that.
Okay, so go back to Vary. Was there anything else that you wanted to raise as a kind of follow-up from yesterday before I move to Mr. McCorriston for the figures? Is that the main issue you wanted, just a further opportunity to address?
That was the main issue. Thank you, sir. I think that the discussion has shown that the sister report analyses the impact of substantially more traffic from the 9 allocated sites in the LDP on the network. And position in relation to the town centre is that with the impact of these developments, with no interventions, the position is a lot worse than if the council takes action to alleviate pressure on the network. That's all that we have to say on the matter.
Thank you. Mr. McLeod? Or Mr. Snedden?
Mr. Snedden.
Yes, that's fine. Of course.
Yeah, just to come back on a few of the points that yourself and Mr. McCorriston were making, sir. I think we've got 4 written down, so I'll just go through them in no particular order, pretty briefly. So even if you accept the 200 trips level, which, to be clear, then the daily variation of 10%, which is accepted in traffic terms, exceeds that. So even if you could remove 200 vehicles, it's unlikely to be noticeable to other road users. Mr. McCorriston's point about the school bus, I thought was pretty interesting, because I think it inadvertently makes our point for us. If the school bus goes from the east end of Springfield to the high school, then in the model, it doesn't. In the model, it goes down the motorway and approaches Linlithgow again from the other end of the town. And it's plainly not going to do that, because Sistra took all of the trips from these zones and allocated them to the west facing slurs. And yourself, sir, you mentioned a few times about travelling from one side of the town to the other. It's really not about travelling from one side of the town to the other in the model. It's travelling from the east end of the town and leaving the model at zone 1, which is going out of Linlithgow again, as if you were travelling further to the west. And that implies a longer distance journey, for example, to Stirling. Now, if, like me, you lived for several years in Black Ness, then you already have west-facing slips at Junction 2. You don't need to build more. So you can already avoid the town by simply using the infrastructure that's already there. And I think the community actually make a point in relation to this in the community statement on page 2. You don't have to get this, I'll just read it, it's quite short. They say in part of 2.12 of their statement, they say, however, it should be mentioned that such westbound traffic, this is East Bowness traffic, currently has a straightforward route through Bowness, which compares favourably with travelling along Linlithgow High Street. Now, from my local knowledge, I would say that's right. In fact, it's probably quicker to travel on that route through Bowness. But we don't know that in modelling terms because it's not in the model. And just to go, the final point on this is this. The council's tried to distance itself from the model report there by sort of shrugging its shoulders and saying, well, it's a model report. But it underpins everything. And if it's flawed, then everything the council are doing in relation to this is flawed.
Thank you. Just in relation to the comments I made, I was seeking to respond to Mr. McCorriston's point about people who might drop kids off at the high school on the way to Stirling. So I accept the point, and my observation was in the context of longer journeys rather than simply going from one side of the town to the other. But I'm grateful for the clarification on that. Thank you.
Can I just add one final point?
Yes, of
already, but Mr. Snedden mentioned Junction 2. That is not in the model.
No. Yeah.
So So one of the trips that Mr. Snedden basically indicates is likely to happen in the real world is simply not modelled as part of the SISTRA model.
Okay, thank you. And just on that issue, is that accepted by the council?
Just conferring here again, sir.
Yes,
Just a second.
Just on that last point, that very last point from Mr. McLeod.
Perhaps while colleagues are conferring, I know you want to bring this part of the debate to a conclusion. I don't want to extend it, but the appellants are very critical of the model presented by SISTRA, the council's model, but they have criticised the model, but they haven't provided their own evidence as to what the position would be. So if they think 200 vehicle movements is too high, what is the vehicle movement that would be removed through the motorway junction?
There's that point in my mind, certainly in terms of the criticisms, the appellee criticisms, one of which is on effectively this discussion about the decision to adopt the policy in the first place. That's what this is about. We'll come on shortly. And I think there is the report from Mr. Snedden's firm, the transport planning firm, that criticises the causal link, the scale and kind test. I think there is evidence that's been produced and was presented, I think, when the original decision was made. So in that respect, on the kind of the causal link between the two that we're coming to, there is some evidence there. But I do see that distinction in my mind between these criticisms of the modelling that led to the policy being adopted. I don't know if Mr. McLeod, you think that's a fair distinction that's being drawn, or appears in my mind, as to the criticisms. There's two sets of criticisms, effectively.
Sorry, sir, Mr. McLeod was going to introduce me there. So, I generally accept what you just said there. I would point out, though, that there was a transport statement that accompanied this application, consultation responses from West Lothian Council Roads Department offering no objection to the application.
Yeah. My reading of those was they were mainly, again, the council can correct me if I'm wrong with that, they were mainly about the more localised impacts in relation to the Preston Road improvements. They said it was right to say that they didn't make any comment on this wider issue, but my reading of those is they made very few references, and indeed there were very few references in the CALA report to the M9 junction, because it too was more focused on the localised road improvements at the site itself. But the transportation comments were certainly, you're right, but largely focused only on the Preston Road improvements.
Well, the council's responses, you're correct. I mean, they're focused more on the site area. But the objective, really, if you're representing a client, is to try to minimise the comments that are being made in consultation responses with a view to keeping them as short as possible, keeping the conditionality as short as possible, and obtaining a consent on behalf of your client. So it's not unusual. It would be. It's more of a problem if you get 12 pages of comments.
Yeah.
Okay,
that's understood. These, of course, are CALA points rather than the appellant's points in this case.
He came into the office and took all of them away. There's no way to keep reference.
So I've got Victoria's hand up and then Vary's hand up.
The only thing that
Getting some feedback somewhere.
The only thing that I wanted to sort of come back on is Mr. Snedden had obviously raised the comment about travelling to Junction 2, and that's based on his local knowledge. But where we would struggle to accept that is that it's about 3.5 kilometres further east from Junction 3. So we'd struggle to accept that people would travel that further distance to get there.
Thank you, Manny.
Thank you, sir. Just with reference to the fact that requirement for the interventions wasn't discussed in the transport consultation response, it is discussed in the Development Management Committee report. So it does come to the point that the transport consultation response focused on local issues, but the requirement for the contributions is discussed in the committee report.
Okay, thank you. Okay, I wonder if we move on to Craig Corson, who whether he's keen to tell me, I'm keen to hear his information on costings, and you said that'll take a few minutes to work through, so please fire ahead.
Yeah, thank you very much, sir. And it will take just a couple of minutes because I just want to take you through the process. So sir, it's probably helpful to have the Section 75 agreement before you, and page 5 of that agreement.
Yep.
And just at the very top of that page, so you'll see that there's a definition of indexation, and it gives a pretty basic formula where we take the B, which is defined as the all-in tender price index for the latest quarter for which the all tender price index has been published, and that references to the RICS all tender price index. So RICS produce quarterly indices of construction price inflation, essentially. So you take the latest index, latest published index, multiply that by the contribution that is sought, and then divide it by the index which existed at the base date. In this case, I think let me just get this right, quarter 2 2019. So quarter 2 2019. Yeah, so at quarter 2 2019, the index was 335. So essentially that's the that's A on the equation. Now the last published index, for some surprising reason, is only quarter 4 2019. I'm not sure why there is such a delay on that, but the quarter 4 2019 index was in fact 333, which is less than the index at quarter 2 2019 by 2 points.
Yeah.
So if you do the maths on that, and you apply the strict definition that is set out in the Section 75 there would actually be a reduced payment if we were to invoice today. And the invoice payment would be £15,842.35, as opposed to 15,938.
Sure.
Which is the base one.
Yeah.
So that's kind of part one of the story, I suppose. Because what we know, sir, through nothing more than watching the news on a daily basis, that construction price inflation since 2019 has, for want of a better expression, gone through the roof. But unfortunately, I suppose, the Section 75 ties us into a process which lags the calculation. Now, to put a quantum on that, the RICS publish estimates for the index, so they're not actual index figures, they're estimates, and their estimate for quarter 2 2023, which is where we are at the moment, the estimated index is 383. Now, if we were to apply the estimated index, which we're not entitled to in terms of the Section 75, but if we were to apply that, the figure payable would be £18,221.46. Now, sir, the particular significance of this is that we know fine and well that construction price inflation is very, very significant at the moment, and the provisional estimate of 383 indicates that. But if you apply the provisional estimate to the base estimate costs for the motorway junction and the interventions on the high street, which, as a reminder, are £8,973,000. So that is the figure which the developer obligations seek to recover with indexation. But we know that the indexation at the moment is actually going to reduce that figure. It's going to reduce the figure that the council gets if we were to apply it just now. But if you apply the 383 indexation to the £8.973 million, then the current estimated cost of the interventions would be £10,258,683.58. I think we can reasonably ignore the 58 pence. So sir, what we've got is an indexation that's playing against the council at the moment. So we know that the current recovery cost would be less. At the same time, the cost of delivering the intervention is increasing. I think the importance of that, sir, is the council seeking to recover 100% of the cost of the interventions necessary? Well, the simple answer to that from the indexation that we've just gone through, sir, is that we will never recover the full cost of the intervention through that route, and that some top-up funding is going to be required. Now, we explained this yesterday, saying we've already not accounted for land costs, and that we are ever hopeful that we'll bring money in through levelling up fund or through the city region deal. The council is part of the Edinburgh and South East Scotland city region deal. We've effectively got a bid in for funding to the UK and Scottish governments through that route. There's a conversation to be had by ministers in a few weeks' time about funding of the regional prosperity framework, which is part of the city region deal. But in summary, the contributions, because of a quirk of the way indexation is calculated, is going down. The costs are going up. We're never going to meet 100% of the costs. We were never doing that anyway, because we hadn't accounted for land values, and we will need further interventions, further financial support in order to deliver this. So hopefully, sir, that's helpful in explaining that. I'm absolutely happy to, either through closing submissions, to detail that, or to give the link to the RICS all-in tender price index indications. That's helpful.
I mean, the main reason why I was interested in the question was on a kind of an assumption, as has been referred to, the fact that construction price inflation has gone up. Had it been the case that the recoverable sum was significantly higher than the 15,938 set out at the figures in the agreement, it would have been useful for me to know that. I can't say I can fully understand why that higher figure can't now be recovered, but maybe we don't need to waste time on that. The fact of the matter is, what you're saying is that the way it would be calculated, at least on the still quite out of date figures that you would apply in terms of the indexation, is it would be slightly reduced and certainly not significantly higher. And that's probably all that I need to know about. I just wanted to rule out in my mind the possibility that that figure was now, massively bigger. And even if it might be higher than the last quarter of 2019, you've explained to me that 383 figure wouldn't be applicable in terms of the agreement, so the 18,221 figure wouldn't really be of any relevance. So I'm content with that explanation from my part, but I'll ask Mr. MacLeod if he has anything to say on this point. I mean, it's really just from my point of view, just ruling out anything that I need to be aware of that suggests a significant difference from what the agreement says. But Mr. MacLeod will have a view on this, I suspect.
Thanks, sir. It was interesting to hear Mr. McCorson's explanation. I have to say I was surprised to hear what he was saying about the index not having been published since 2019, and that's not criticism of him at all. That's just an expression of surprise. How relevant it is to the issues that you need to determine, sir, I'm not convinced, because ultimately I think it comes back to the question of the principle of the contribution.
Yeah.
And indexation doesn't really go to the question of whether the principle of the contribution is justified and whether the principal sum was justified, and that's linked to the intervention itself, and we'll come on to discuss that later.
Yeah, I think that's right. I think Mr. McCorson's going to come back on that as well. I think that is right, but I just wanted some assurances that we weren't talking about huge different figures, even though, as I say, we are going to be talking to principle. But Mr. McCorson.
Yeah, so thanks for allowing me to come in again. So, yeah, I don't disagree with Mr. MacLeod that you have to consider the principal compliance with the circular, and you will no doubt do that with all the evidence before you. You have sort of alluded to whether you needed to understand this or whether you needed to do anything about it. I mean, although the headline figures are perhaps not significantly different, what it does mean is that but by those estimates, the project delivery is going to cost something like £1.4 million more than essentially the base estimates that the council were looking at, and it is, as you've identified yourselves, are open to you to, if you were persuaded about the principle, it would be open for you to change the figures in the agreement, or indeed change the method of calculation. And this is something that the council will reflect on in future Section 75 agreements, given that there is now a significant lag in the RICS confirming the index. But as I understand it, sir, it would be open for you to change the definition in the Section 75 to allow the provisional index to be used in terms of that calculation rather than the published index, and that would ensure, if you are persuaded about the principle that's being applied here, that the greater proportion of the overall cost could be recovered through developer obligations and the indexation applied to that. I say, so that's not the council's position at this point in time. I'm simply responding to your quandary about what you might do with this if there was a significant difference, and the difference by the best estimate at the moment is £1.4 million.
Okay, thank you for that. I mean, to a certain extent, this issue may go back to Mr. MacLeod's point that we discussed yesterday, and the previous case from the reporter submitted that we'll need to reflect on. I mean, I suspect won't spend time on this just now. If that was an avenue that I was minded to go down, I think that would require a wee bit of additional evidence, more than we've had just now. To be honest, it's not something I'm inclining to looking at as an option. I raised it yesterday because it did strike me as something that was potentially open. But I think I'd probably at this stage prefer to focus on the points Mr. MacLeod has made about the principle of what's arising there, rather than looking in detail at this issue, since obviously it was as much news to me as it was to Mr. MacLeod that the circumstances of the way in which this is calculated has fallen slightly out of kilter than what the council perfectly reasonably might have anticipated back in 2018, 2019 when this was being developed. So I think that that's helpful to be aware of that. But I think the focus, probably from my perspective, is on the issues of principle that the appellants are taking.
That's fine from my perspective, sir.
Moving on to that, item 2.9. Can't believe it's taken us an hour and 5 minutes, and we're only moving on to the second item of the agenda. That's the way these things work. Obviously, I'm familiar with the LSIC case. I've seen the arguments that are there. I've got an issue I'd like to explore kind of specifically about how LSIC should be interpreted in the context of the circumstance arising in this particular case. But I'll maybe just give, first of all, Mr. MacLeod an opportunity just to say anything further. And then maybe Mr. Alexander, maybe Ms. Foy, who wants to talk on behalf of the council. I know they've been dotting to and fro of different aspects of which bits they're covering, but in relation to the kind of the general approach to the scale and kind test, and moving on from the issues we were discussing primarily yesterday of the underlying principle, the justification for the policy, the issues relating to the supplementary guidance, all those issues from yesterday, I'm keen to move now on to specifically the test and the circular in relation to scale and kind. And that probably, is primarily where the LSIC issue, certainly in my mind, it comes into play, is the question, which is really issues on items 2.9 and 2.10 of the agenda. What does LSIC actually mean for us, and what is the need for the causal link, and is it established here? I'll maybe move to Mr. MacLeod for anything general you want to say about those things, then I'll ask my question once I've heard from the council. The legal side.
Not a great deal, to be honest with you. You have our submissions in writing. The council's response to your question makes the point that LSIC was decided on the basis of legality rather than it being a breach of the circular, and we agree with that. That is clear from the terms of the judgment. What the judgment, though, focuses on is the degree of connection between the impact of the development in question and the contribution that's being sought. And we had quoted from the circular itself, which says, this is paragraph 20, an effect of infrastructure investment may be to confer some wider community benefit, but contributions should always be proportionate to the scale of the proposed development. Attempts to extract excessive contributions towards the cost of infrastructure or to obtain extraneous benefits are unacceptable. So that's what the circular had to say on the issue. When Lord Hodge came to look at the circular, what he said was that the pooling of fixed contributions towards the funding of infrastructure, which include infrastructure interventions, which include many on which a particular development's impact is minimal, does not meet the criterion in the circular that the obligation is fairly and reasonably related in scale and kind to the proposed development. So what you have there, sir, is a Supreme Court judge giving you his interpretation, which was agreed with by the other justices, giving you his interpretation of what the circular means. And in essence, a contribution which has or an impact which is only minimal, does not meet the scale and kind test or fairly reasonably related as per the circular's requirements. That's probably about all that I need to say.
Yeah. Okay. So going to the council's legal team on this issue.
Thank you. Yeah, I'll come in on this point. ELSIC in some ways is very straightforward, and it just reaffirms a key legal principle when you're dealing with planning obligations. And certainly my take on it is what happened there was that the court found that there must be more than a trivial connection between the development and the intervention which the proposed contribution will fund. That to me is it in a nutshell. And we can obviously go on then to talk about the circular tests. So we've got the legal tests in that way, and the circular tests make it clear on scale and kind that you can take into account the cumulative impact of a number of proposed developments and use obligations to share costs proportionately. So that's it in very brief terms in terms of the legal tests and the circular tests on scale and kind. And hopefully our submissions that were helpful. They obviously go wider than that, but when you distill it all down, that's my take on it, certainly.
One of the issues that was in my mind, and certainly looking at what Lord Hodge had said there, and the proportionality, and the need for there to be a link, it struck me, and Mr. McLeod makes the point that it's not a policy issue, it's a legal issue, but it had struck me that the circumstances here are arguably slightly different from those that were applied in ELSIC, which dealt with transportation contributions across the Aberdeenshire and City, and imposed, even though the ELSIC contribution was a relatively small one towards the overall requirements that were there, nevertheless that was excessive and fell beyond what was legal in those circumstances. But the focus in relation to the ELSIC case was an attempt by the two councils working together to try to ensure that transport infrastructure across the two council areas were given effect to on a kind of councils wide basis effectively. In a sense, while still requiring to meet that test, what strikes me here is the issues we discussed yesterday. In terms of the council's policies, that this is a bespoke solution around Linlithgow. It gives rise to a whole number of other factors that come into play, including the historical circumstances once an area of restraint and now certainly no longer, as I understand it. But there are a number of factors, and obviously the causal link is a crucially important one. There are other factors that come into play, such as the air quality, the interconnection between the two of them. While we will address in a moment some of the criticisms that have come from the appellant on the extent to which the link is established, it has struck me that there's maybe a kind of more multidimensional set of circumstances being faced with in the town of Linlithgow that require to be addressed. And as Mr. McCorson made the point yesterday, the issues of air quality and congestion in the high street can't be looked at in isolation from the proposal for the west facing slips. And whether that creates a kind of slightly wider and slightly more nuanced policy context within which the test in ELSIC requires to be applied. So there was a bit of a thought from that point of view on which I'd invite views of parties. I'm going to go to Mr. Alexander first on that because his hand is up, but then Mr. McLeod. You weren't wanting to respond to that particular point. You had another point in mind, but fire ahead nevertheless.
No, I think my point really was just context, of course, is important. And what the Strategic Transport Fund tried to do was to cover, obviously, geographically a very big area, Aberdeenshire and Aberdeen City, covering 6 transport interventions over a large different area and trying to have a joined-up approach to strategic transport infrastructure. all I'd say is the legal test, as I've set out, that's the position, certainly my view. But all I'd say is here we've got quite a different scenario, as you've articulated, is we're effectively dealing with a bespoke solution for a town centre, and particularly the high street, where we need a transport solution through transport infrastructure requirements.
Okay, thank you, Mr. Clyde.
Thanks, sir. Yes, I mean, I fully accept that the LSIC situation is factually different in Lithgow in the sense that it covered a wider area and a number of different transport interventions. The principles, however, are the same, and the question is whether this development and this application or appeal side, whether this has an impact on the need for these slip roads that can be justified in terms of the level of contribution that the council is asking for. Now, air quality was mentioned in the comments that you were making there, sir, and what we have seen as this process has moved forward is that air quality has really become the justification. Improvements in air quality in the town centre has really become the council's justification for the slip road intervention. I'm not clear whether that was always the case, but that certainly seems to be the council's position now. The difficulty for the council is that the evidence doesn't show that there is an air quality problem that needs to be resolved. The air quality management area, I think if the council was exercising its duties properly, the air quality management area would have been revoked based on the evidence that we've referred to yesterday and in writing. And indeed, when CALA came to submit their application, they submitted an air quality impact assessment with that application. Council initially proposed a suspensive condition that required an update to that, but latterly removed that condition because they were satisfied that an updated air quality impact assessment had shown that the development would not have an adverse effect on the town centre. So, in very basic terms, what we have is a council that acknowledges this development would not have an adverse air quality impact on the town centre. Evidence that suggests that council evidence suggests that none of the traffic from this development would actually use the slip roads at all. And yet the council wants £1 million from the applicant. That doesn't, on the face of it, appear to be fair, reasonable, or proportionate.
Okay, thank you. Mr. McCarson, well, we're going to come on later on to the air quality connection a little bit later on, but I accept the point and understand the point, and we discussed that a little bit yesterday. I'm going to bring in Mr. McCarson just now, but I'm then going to ask Mr. McLeod to bring in Mr. Snedden to talk on the traffic aspects of the link, the causal link, and the evidence that's presented by the appellant. I think it's essentially based on the sister assessments, to just expand upon the appellant's arguments in relation to the lack of a connection that's been suggested. I'll bring in Mr. McCarson first, I think, wants to comment on the points just made, then I'll come to Mr. Snedden to move on to the traffic impacts.
Yeah, thank you again, sir. And it was really to just again pick up the point that you had made yourself in terms of my position, which I had set out yesterday, and to respond to some of the points made by Mr. McLeod there. The council's position is that traffic has to be removed from the high street. That's the council's position. That's a development plan position. Sorry, just to clarify that, traffic has to be removed from the high street if development is to be supported in the town. The development plan is absolutely clear on that, and that's the council's focus. There is a causal link to air quality. We've heard the position with air quality. Of course, we also heard the UK government's announcement yesterday that's delaying the prohibition on the use of petrol vehicles. So, you know, who knows where we're going to be in terms of air quality going forward. But the council's focus with respect to development in the town is supporting development, and in doing that, it has to remove traffic from the high street. We've set that position out. I hope that position is clear, and thank you for that, sir.
Okay, thank you. Okay, Mr. McLeod,
it was just really just one question. I couldn't immediately remember, but Mr. McCorriston was saying that the council's justification is traffic has to be removed from the town centre if developments to be supported, and that was clear from the development plan. Could you give us a reference in the actual development plan that says that?
Well, sir, Steve Lovell will be able to pull out the references, but I gave the references yesterday, which started from essentially the examination report, where the council set out at the examination that it was a no net detriment approach that was being adopted in Linlithgow, and the reporter accepted that position and made no changes to the plan in that regard. But I see Mr. Alexander's got his hand up.
Yeah, maybe that Mr. Alexander's got the answer to this.
Yeah, I mean, I think I've covered, I think between us we've covered this, but just so we're all the way, we are in the LDP, paragraph 75 explains the reasons for removal of the area of restraint, and it's quite clear that the infrastructure requirements are needed in all relevant environmental considerations of the town. Once they consider that, it was concluded that there could be some development in the town. The LDP then goes on to outline the 9 allocated sites, which is clearly what we're doing here. We're releasing 624 units in Linlithgow, and it's clear from the LDP that the area of restraint was removed because the infrastructure requirements could now be addressed. Two of them principally education and, of course, transport. And I'll probably just leave it there for now. Thank you.
Yeah, could you just remind me the paragraph? I think you said paragraph 75. Did I pick up correctly?
Yes. There's obviously references throughout the plan, but 75 gives the history for the removal of the area of restraint.
That's helpful. Thank you. Anything further on that, Mr. McLeod?
Sorry, for the loss of
That's
okay.
If you want to take a bit of time, I'm going to have a break at 11:30. If you want to take time to come back to that point separately, if there's anything further you want to say, don't forget to make any further observations. I was going to ask you to invite Mr. Snedden to kind of move on to the kind of the linked questions of the correct contribution, if indeed a contribution can be justified. What the correct contribution in Mr. Snedden's view would be, and that's under reference to the council's 100% argument, under reference to the indications in the appeal document, and there's a table that's kind of produced in the statement of case for the appellant, dealing with the percentage of split development traffic, and that reference, I think, a 15.1% contribution towards the traffic. Thirdly, breaking down, because I think the appellant's argument breaks that down further and references in the table, it's a paragraph 6.20 of the appellant's case, specifically to the Deanburn Road site described there as Preston Farm, that suggests no movements would use the west-facing slip. So there's kind of 3 dimensions to all of that as I see it. I don't want to dictate to Mr. Snedden how he makes his representation, but they're the kind of the 3 headings that I think are on my mind about the kind of council's justification for the percentage they seek And if 100% is in Mr. Snedden's view not the right figure, what is the right figure?
Thank you, sir. I think in my estimation, it's two locations that you can find the answer to this.
Okay.
And they are in A018A, which is the transport statement that accompanied the application.
Yeah.
At paragraphs 417 to 424 in a section called wider traffic impact. And you can read that for yourself, sir, and perhaps afterwards, but I'll just read it's not the concluding paragraph, but the second last paragraph says, the majority, if not all of these trips, and by this point we're talking about 9 trips, would use the east-facing ramps at junction 3N9, so to go to and from Edinburgh. And then we say in that report, but if for some reason, not necessarily a reason that we could envisage, but if for some reason a portion of these trips were to use new west-facing ramps at junction 3N9, we cannot envisage that number being greater than 1 or 2 trips, and well within the bounds of trivial.
Sure.
And then the other place that you can find this is back in the council's report at 116 of the sister report on page 7. Just give you that reference again, sir, because I can see you writing it down there. So it's 1.1.6 on page 7. And just at the foot of that page, there's a bullet point. It's quite short. It continues over onto the next page. And it says, it is anticipated that development traffic located to the west of Linlithgow will not route through the town centre to access the westbound on slips to travel west. So thinking about the development impact directly that may be felt on the slips, then reading these two things together, the answer is 0.
Well, you're not saying that, presumably you're not saying that literally no cars from the Deanburn estate would use the road. What you're saying is the modelling suggests that the level is effectively de minimis, effectively trivial, such a trivial level that it's not appropriate to be taken into account for the purposes of this exercise we're undertaking just now.
But the second part that I read out to you, sir, was from the council's own study.
Sure.
So in our own report, we did say that 1 or 2 trips might use this for some reason, but the council say that it would be 0.
Okay. I'm going to bring it. Mr. McConnell, do you want to discuss? I don't want to interrupt Mr. Snedden's flow. Do you want to come in just now, Mr. McConnell, or do you want me to continue with Mr. Snedden just now?
I'm happy for you to continue with Mr. Snedden.
If you just turned my tap off at that point, so I didn't have anything to add to that. I thought it was fairly clear.
So the relevance then, the appellant refers to the sister report. I think what you're saying is that this is unsubstantiated even by the evidence that you've quoted from the council's report, but that one of the reasons why 100% is wrong is because of the table that's produced at paragraph 620. 15% is the right figure across the 6 sites taken collectively. So I'm just interested in your view. I'll come to the council's transport witnesses in a second. What's your view about that collective 15% then? You've mentioned specifically, very helpfully, referred to, I'd certainly clocked the first reference in the applicant's transportation report of the Deanburn Road site specifically, but taking the 6 as a whole suggests that the collective contribution is 15%, and I'm just interested, because that's part of the appellant's case, I'm interested in what your view is on the accuracy of that, given that it's taken from the sister evidence.
You'll have to give me a second, because we don't have that table right in front of us right now, I'm afraid.
Well, should I bring in Mr. McCorriston, and then we can take a short break, and that'll give you a chance to look at the table and take this forward after a short break. Mr. McCorriston.
Thank you, sir. I'm just I'm trying to work my head round this. So the appellant is relying on the applicant's transport study to support their case, is kind of what I'm getting here. However, remember that the applicant who submitted the transport case accepted that, notwithstanding the terms of their submitted transport study, that the applicant accepted, because of the issue of impact on the high street, the applicant accepted that the contributions as set out were justified. So the appellant seems to be relying on a document which the applicant submitted and essentially set aside, if you will, and agreed that contributions were justified. So I'm just struggling to get where the appellant's justification for all of this is, if they are relying on the applicant's case. Thank you.
Okay, I'll bring Victoria Munkle just now and then go back to the appellants.
Thank you. So there's just two small points that I want to make. I just wanted to bring your attention under 4.3 in the transport statement. It's noted that there's a reference there to the West Lothian Council study. And in preparation of this study, they've identified themselves that one of the main points of our study was the traffic pressure on the high street. And then the second thing that I just wanted to mention was there was mention there of 1 to 2 trips on the slips as a result of this development, which, you know, I understand that point, but I think it's important to note that when assessing it, we absolutely have to assess it as a cumulative total of the developments as a whole.
That's cumulatively, presumably amongst all the 6 sites that have been identified.
Yes. Yeah.
Mr. Snedden, I think it's you. You don't want to cover numbers per cloud.
I was going to come back on Mr. McCarson's point and then suggest that we break at that point, and then we can have a look at some of the technical stuff and give you a more focused answer on some of that once we come back. Mr. McCarson's point with respect sounds like a lawyer's point, and again, with respect, not a very good one at that. The appellant in this case is basing its case on the evidence that is available. Some of that evidence comes from CALA in terms of its planning application. Some of that evidence comes from the council in terms of the modelling exercise that was undertaken on their behalf. We are simply focusing on what evidence is out there at the moment. And just because CALA may have said something as part of the application doesn't invalidate what the transport assessment and the transport modelling work shows. And I'm sure, sir, you appreciate the distinction between the two yourself.
Thank you. We'll take a short break just now. It's just on 11:30. I was going to suggest coming back at 11:45 to give us just a fraction more than the 10 minutes. So we can all get a cup of coffee or whatever in the break. So we'll reconvene at 10:45. Thank you. I think it's 11:45 now. I think I said 10:45 earlier on. But I was saying we'll reconvene, but hopefully I've not confused everybody. We're operating in different time zones than everybody else. Right. Mr. Snedden, I think, was going to start. Oh, Mr. McLeod, you wanted to speak there. You're on mute just now. I think Mr. Snedden was going to delve into some of the more detailed issues. Mr. McLeod, you may also want to come back on that point about the reference made by Mr. Alexander to page 75 of the LDP. I don't know if you've had a chance in the break to look at that before you bring in Mr. Snedden on more technical issues.
And actually, I think the point I'll probably just cover in submissions. There are other paragraphs round about there, and it's probably a matter of submission as to what the development plan actually means anyway. So I'm quite happy to deal with that then.
Yes.
Yeah. So in terms of the point about the 15% that you referred to, there are probably two documents that are worth referring to. One is the supporting statement that accompanied the appeal, because that sets out the summary of the position.
Yes. I think that's what I was alluding to earlier. Yeah.
Yes. Yeah. And then I think, sir, from what we picked up, what you want to do is understand where that argument comes from, but probably by reference to the SISTRA document.
So, I think so, yes. That would be helpful. I saw the argument and I understand I think it's 15.1% from the table at paragraph 6.20, but it's the interrelationship with that and the SISTRA document, I think, is the bit I'd appreciate some assistance navigating my way around to understand what that document says and means, and what your clients and your transportation witness makes of that, and the interrelationship between the two.
Absolutely. So for everybody else's benefit, it's the modification supporting statement that was submitted as part of the appeal that sets out the summary, and then Mr. Snedden is going to, and I don't think that has a document number actually.
No, it doesn't.
No. And then Mr. Snedden's also going to refer to the SISTRA report, and in particular, I think it's towards the very end of the SISTRA report, Appendix 1.
Just Appendix 1.
Yeah, Appendix 1.
Yeah.
I'll maybe just hand over to Mr. Snedden then.
Okay.
So, sir, in the supporting statement, we're starting at paragraph 617.
Yeah.
And I think that the confusion, or certainly my confusion, was your reference to the 15%. So
yeah,
I get that. I get where that might have arisen now. So we'll just walk through that. So in 617, it refers to the PM table in the SISTRA report on page 35.
Okay.
And the reason that it refers to the PM table is because that's the worst case scenario.
Right.
And in that table, which is the lower table on that page, it says new development zones using the west facing slips. And in the final row, it says that there'll be 20 trips to the west facing slips and 20 trips from the west facing slips. So 40 trips.
That's where the 40 vehicles comes from.
That's where the 40 vehicles come from. And then the paragraph goes on to say, paragraph 617, those 40 vehicles relate to 4 development zones within Linlithgow. And the application site is not within any of these zones. So the paragraph then goes on to say the existing traffic predicted to use the slips is 216 vehicles. Now, back at the sister report, if you turn the page or scroll down a page, then there's two longer tables. And the lower table has numbers for the existing zones that would use the new west-facing slips. And if you add up the numbers across the bottom of that table, which is 92.4 and 120, then the existing traffic predicted to use the slips is 216 vehicles.
Okay, yeah.
All right, so the 15.6% comes from, is the proportion of the 40 vehicles using the slips.
Okay.
The point to stress is that because of what I said before the break in relation to the report, not the sister report, not allocating any housing trips from the west of the town,
Yes,
to slips at the east of the town, despite these numbers, there are no trips projected to use the slips arising from Preston Road.
is that because they're not mentioned on page 36 of the sister report, or are they mentioned with a nothing next to them? I was looking at those tables previously. I was trying to see which of the zones that are referenced on page 36 I could match up with either Preston Farm or Deanburn Road. And I didn't see any reference to them there. So is your nothing because they're not referenced, or is there a reference that says nothing?
No, they're not referenced. So the zone references in the tables on page 36 are in the first column of each of the table where it says VISM zones. And the zone where the development is would be zone 20. And you can see that it's not there.
Okay.
And that is consistent with the no trips would arise from the development that would use the slips. And that's why in the table on page 8 of the statement, under HLL 12 Preston Farm.
So that's the supporting statement. Yeah.
That's why the percentage split of the development traffic in the end column attributable to site HLL 12 is 0.
0. You add all those together, that gets you 40. If you look at the right-handmost column, all the 6 sites taken together, of which on that table, Preston Farm has a 0 contribution. That's the point you're making.
Yeah. That's right, sir. And just to sort of complete that loop, if you come back to the table that Mr. Snedden referred to, first of all, that's the one in the sister report. So page 35 of 38.
Okay.
This is the
Yes.
It's on PDF 76 of 80 if you're using the long document.
Thank you.
So that table is new development zones using the west-facing slips. And what that does is it shows the zones on the left-hand side. It then shows the relevant development sites that have been allocated in the LDP. And you will see that the appeal site is just not there. And the reason for that is Sistra's view was that no development traffic from the appeal site would use the slips at all.
Yeah. Okay, thank you. That was really one of my questions in trying to interrogate and understand the sister report. So it's the absence of reference there. So that's helpful to get a sense of that.
So I suppose, just to kind of summarise then from a sort of proportionality point of view, assume for the purpose of what I'm going to say that we agree that there is a need for this, but that is just an assumption.
Sure.
But from a proportionality point of view, what you should really be looking at is local development plan allocations contributing a maximum of 15.6% of the costs. And of that 15%, the appeal site should contribute 0 based on the council's evidence.
Okay. Is there anything else you want to say, Mr. Said, before we go to the council?
Nothing
for
for
the
me, sir.
transportation. Yeah. Yeah. Okay. Well, I'll move across to the council transportation witnesses just to respond to that. And as part of that response, I put to Mr. Snedden the kind of the idea that it would be surprising if nobody from the Deanburn Road site ever used the west-facing slips. And I wonder if I could ask the question the other way around to the council as well. When you look at the tables that have just been referred to from the sister report, and I'm looking there at the tables at page 36, bearing in mind that the council suggests that the contribution should be 100%, it's clear from that there are a range of sites that vehicles will use the west-facing slips from. I guess I pose to the council the reverse of the question I put to Mr. Snedden, is that looks like evidence that suggests there is other usage. I mean, common sense tells you there's other usage, but that document itself does suggest some analytical information suggesting that use of the road will be by others. And so it goes again back to that question of the justification for the 100%. And then beyond the 100% justification, what's the justification? If it's less than 100%, what is the correct figure? So I'm going to go to the transportation witnesses of the council. But you can Mr. McCorriston first.
Yeah, thank you, sir. And just to give colleagues in transportation some thinking time. So, I mean, I think the position from the council is, you know, we can go through the detail of it, but the principle of what is set out in your question and the response from the appellant in relation to the motorway junction is well understood. The issue in the town is the high street. So the council's focus is how much traffic from the development site will use the high street, and how do you create capacity on the high street to allow that traffic to utilise that piece of infrastructure. So as I set out before, that the motorway junction is the solution, but it's not the problem. The problem that we have to resolve is the high street. And I think so that this goes to your assessment of the uniqueness of the situation. That we have a very linear town in Linlithgow. There is only one route, effectively one route through the town. We want to support development in the town, but we have to create capacity to do that in the high street. So while I understand the argument that this is about how much traffic uses the motorway junction, that or what proportion of the development traffic uses the junction, that's not the issue from the council's perspective. And I appreciate you've got to test everything against the circular and against the provisions, but you've identified yourself so that it's a unique situation. It's a situation where we have, if you listen to the planning forum, we've already tipped the balance. Your proposition yesterday, sir, was, are we just about to tip the balance? Well, we are, and we need to find a solution to that. And to me, it is wrong to focus on how much of the traffic will use the motorway junction and what percentage of that is payable. So I know question 2.11 is about you know, what percentage figure is correct. You know, I put it to you, sir, that if we can't secure the improvements to the high street through developer contributions, something close to 100% contributions, because that's what the development plan says we should do. How do we find a solution to the problem in the high street? That there is no solution to that if we can't secure contributions from developers who are being facilitated within the town to construct houses. The council's in a no-win situation here. So you know that's the planning position on it. Victoria might want to say something specifically about the detail of the junction itself, but to me that is looking at the problem from the wrong end of the telescope.
Okay, thank you. And your hand is up, so I'll bring her in now.
Thank you, sir. I just wanted to say two things. Firstly, on page 6 of the SISTRA report, the slips are there to address the town centre pressure, which Mr McCorriston's obviously explained in detail there. Traffic from the developments is considered in this, and that includes the Preston Farm. So it is included in the overall consideration and assessment. And the second point that I want to make, and it's one that I've kind of made previously, is that in our assessment, we have to assess these in an overall situation. So whilst there might only be 1 or 2 trips onto the slips from this development, the development ultimately brings additional pressure to the high street, and that is what we have to alleviate.
I think the point was made yesterday, just drawing those two things together, just to make sure I understand this properly. The point was made yesterday that the reason why the 6 sites are all treated effectively equally is because their relationship with the high street is the same as each other. They're all different places. They may be located in different parts of the town, but the relationship with the high street is the same as each other, even though, as I think I'm taking it is accepted, the relationship with the west-facing slips is not. I mean, is that a fair summary?
That's a very fair summary, sir.
Yeah.
So okay, just in relation to the council position, is there anything further you want to say, if you like, in relation to kind of the technical aspects of what we're discussing at this part? I've certainly got the generality of the point there, and in response to the points made by Mr. Snedden, is there anything further you want to add on those technical issues on the SISTRA report?
Nothing further from us, sir.
Okay, thank you. Excuse me, I slipped some coffee there. Okay, thank you. I'll go back to either Mr. Snedden and Mr. MacLeod to see if there's anything further you want to say. Your points understood from earlier, and you've heard both the responses from the planning and the transportation witnesses from the council. But I don't know if there was anything further you want to say, or on a technical nature from Mr. Snedden, or anything. I dare say Mr. MacLeod will deal with this in closing submissions, whether there's anything you want to say at this stage in relation to the points we've just been discussing.
I think the only point was just coming back to the transport appraisal that was lodged with the planning application. Mr. Snedden was just going to give you a couple of references from that as to the traffic that would be generated by this development.
Yeah, sir, I already referred you to the relevant paragraphs a few minutes ago. So yep. It was 417 to 424 in a section called wider traffic impact.
Yeah.
And it was really just to save you looking for this information later, but at 420, I'll just read this to you, it's only 2 lines. It says, this means that in the AM period, trips to and from the east, so along the high street to the east of Preston Road, would be 5 in and 11 out, so 16 trips. And in the PM period, 12 in and 7 out, so 19 trips. So we would, I mean, these trips are extremely small in number.
That trips just in and out of the Deanburn Road site?
Yes.
And that's at peak times?
Yeah.
My only thought on that, I guess, I mean, maybe you can just, I'm wrong about this, those do seem quite small figures for a 60 development housing site where the kind of we had some evidence yesterday that you might expect a typical car ownership, maybe not usage, to be two per house. You'd expect car ownership in houses of this size to be of a reasonable order. I know you're only talking of peak times, but it seems a sort of gut reaction as if those are quite low figures in relation to a 60-unit development. With a 55 or a 58 point something percentage car usage, which is Mr. McCorrison's evidence from yesterday.
Yeah, so that's one direction. I mean, clearly there are other directions available.
Yeah,
but I thought that we'd really been focusing on the high street. So
no, absolutely not. Understand that. That's helpful.
I'm happy to go over the trip rates again, but we did that yesterday.
Yeah, okay, that's fine. It was just an observation reflecting on what we had yesterday. Okay, that's helpful.
And my final comment on that is those trip rates were agreed with the council, so that that is agreed evidence as to what the trip rates are.
Okay, so that's helpful too, from that perspective. Mr. McCorrison.
Yeah, thank you, sir. And I'm not going to go into the details of the figures itself, but while you accept they are or comment that they are surprisingly low, bear in mind that the council's position is one of cumulative impact across the 6 sites. So if you start to aggregate those figures up across the 6 sites, and this is a comparatively small site in terms of the allocations in West Lothian, in Linlithgow. We heard yesterday that one of the applications was for 400 houses. So it's that cumulative impact that has an impact on the high street, and if you calculate that cumulative impact and compare that to the mitigation which is obtained by the motorway junction, you get central to the council's case on this.
I guess just looking at the council's case, and again reiterating the point you make about the cumulative nature of it. This is a 60-unit site, but of course for these appellants, it's actually only 1 unit, because there's only 1 unit left. Now, obviously, we can have no idea whether the occupiers of plot 54, I think, is the one that's left. You simply can't tell in advance at this stage what that one person, what that one family would use the site on. So this was the thought that's going through my mind when I heard about the title, the title transfers. And I know and I accept that makes no difference in the principle of what we're looking at. It does come to my mind as an issue of what's the correct sort of control, effectively. What's the standard by which it's appropriate to assess this information from? Is it the 563 across the 6 sites collectively? Is it across the 60 in this one development, or is it the appellant's only house? Because once you get to the only house, you can draw no conclusions in advance, because that becomes completely random. Okay, for thought for me, I think, on a number of these issues. Okay, moving on to item 2.12 of the agenda. I think we did touch on it a little bit yesterday when we were looking at the issue in relation to the neighbouring council, and I was grateful for the confirmation, which I hadn't realised, that Bowness is in fact in Falkirk council area. Item 2.12 mentions the reference in the direction to the forecast and traffic demand appearing to relate to planned development out with the council's area. I have to confess, I was a bit puzzled by the PARD reference to that, insofar as any improvements that are done to the particular trunk road network are liable to be used by persons living out with the West Lothian Council area. And of course, we know that the contributions can't be sought from those who bought houses already in the past. So we can't look to the past for that information. And clearly, planned development out with West Lothian area is not something that's within the powers of West Lothian Council to control. So I was slightly puzzled, and it might be useful even just to ensure that I'm less puzzled as to whether there is any relevance of that particular issue on the matters before me. It didn't seem to me as if there was. I know it was in the direction, and you can understand at one level why it's said, but for the purpose of the question before me just now, I didn't really see any particular relevance, largely on the basis that West Lothian Council cannot require development contributions from people who have permissions out with their own council area, in the same way that they can retrospectively require those people who are owners of property within Lithgow or elsewhere to pay. That it may be a misunderstanding what the Scottish Government direction says. I possibly go to Mr. McConniston first of all on that, since he may have a better understanding from the kind of the general background context of the direction that was served. And I noted yesterday he did reflect the fact that some of the discussions with the Scottish Government are obviously confidential. But any views on this issue?
Yeah, thank you, sir. I'm not sure I've got a great deal to add to what we said yesterday. I mean, like yourself, we were perplexed by the reference, and that's why we entered into extensive discussions and negotiations with the chief planner in an attempt to resolve it. I did make reference yesterday to the wording that's in the direction, which is on the evidence presented, that the case hadn't been made. And we've had a very helpful examination of the evidence through the appeal hearing yesterday and today, and there's clearly, in my view, some matters which could have been better represented to the Scottish ministers when the case was made, or the supplementary guidance was made, and the door remains open to us to pursue that, notwithstanding what we were saying yesterday about the provisions of the Act now essentially removing supplementary guidance from the process. And I think there's some provisions in there where if the process had started, we can complete the process. But I've not looked at that in any great detail, because I think we need now to address this through a different route. But I think, with the greatest of respect to the Scottish ministers, there's a misunderstanding of the reality that if you build a piece of infrastructure, others will use that infrastructure, others will benefit from that infrastructure and won't contribute to that, because we can't obligate them to. With the greatest of respect to yourself, sir, I don't know where you live, but you did indicate that you took part in the Winchborough Park run.
I do indeed, yes.
Well, of course, the ground upon which the Winchborough Park run takes place is a remediated landfill site, which is now a very attractive country park, 100% funded by the developer in Winchborough, and the house builders there will make a contribution to that. But if you're not a new house purchaser in Winchborough, you will use that infrastructure at no cost, at no charge, and that's just the nature of the process. So it's inevitable that some people will benefit from the infrastructure. In the Linlithgow case, the residents on the east side of the town will be beneficiaries of that infrastructure, because it will make their access to the west much easier. But that's not the issue. The issue is, how do we facilitate the building of houses in Linlithgow, and how do we get the infrastructure in place that delivers that? And the only way to do that, as I can see it at the moment, is to find public funding. That's not going to happen, or we secure, as the development plan says, the contributions from the developers of those 6 sites. So apologies, sir, for the long-winded answer there, but we are as perplexed as you are about the reference to things which essentially we have no control over.
Well, thank you. Mr. MacLeod?
I think we've probably covered this to a large extent already, and I think it perhaps relates back to the point we were discussing a moment or two ago. So what you have is a SISTRA model, which in some scenarios models what the effect of real traffic the Falkirk area will be. And Mr. Snedden's taken you to tables 10 and 11 previously. I obviously can't speak for what the former chief planner had in his mind, but the way that I had read it was, looking at the SISTRA model, you have some significant amounts of traffic coming from Falkirk, impacting on Linlithgow, and yet the individual new developments within Linlithgow are being expected to carry the can for any mitigation that might be required for all of that traffic, as well as for any impact that they might have. It's the point about the pre-existing problem and what the circular tells us about new development not being appropriate for new development to solve pre-existing problems. If there's a pre-existing problem, that needs to be addressed. The new development, if it does have an impact, will have to mitigate that impact. But what we have here, and I think this is the point that the chief planner was making, is you have a model that takes account of substantial amounts of traffic coming from Falkirk, and yet seeks to have the new development mitigate that impact.
Okay, thank you. I mean, I know that ties in. I understand that ties into the kind of the wider arguments, including the appellants make here, and they pray that decision making by Scottish ministers and the chief planner in aid of all of that. But the point is generally understood, and as I say, perhaps the Falkirk example is just a sort of a sub-argument underneath that, as opposed to being the principal argument. But your point is it's all consistent. It'll all be consistent with what the appellants are saying. Okay.
There was one, and I don't know whether it's strictly related. It probably is. It comes to the point about the fact that part of the slips are proposed to be constructed within Falkirk Council's area. And from what I understand from yesterday, the council says it doesn't rely on the supplementary guidance, but instead what it does is it relies on its own local development plan and presumably policy INF1. Now, if the contribution is justified by reference to the local development plan only, the local development plan clearly can only relate to the council's area. There is a different local development plan in a different local authority area that deals with whatever it is they may choose to do over there. And I wanted to raise it at some point today, sir, because I'm interested to understand from the council if it relies on the part of the LDP that says we will safeguard slips in our area for development, how does that then justify a contribution to something in someone else's local authority area?
I don't know if Mr. Alexander wants to come back on that. Since the question is a mixed planning and legal question, but maybe a starting point is a legal one.
Yeah, I'll start us off, and I'm sure others may have comments. as well. I suppose the fundamental point is that traffic on the high street needed to be alleviated, and the council have identified a package of works which can't work independently, a package of works to resolve that issue through the sister report, identifying the west-facing slips and the town centre traffic management improvements. So the focus there is to find a solution to the high street, obviously within the council's area. They then have to construct and implement those works when the time comes and funding has been secured through planning obligations. And I don't see how there is an issue for a council to deliver a package of works which would undoubtedly involve Transport Scotland, given it's a main trunk road, to deliver that bit of infrastructure for the benefit of their area, particularly the issues on the high street, which was one of the key reasons, fundamental reason why the area of restriction was lifted for the 9 new sites to come forward.
Okay. I don't know if Mr. Corson wants to add anything to that.
Probably not very much, sir, because with respect, I'm not quite sure understand what the issue is. My understanding, I absolutely get that the north side of the motorway is in the Falkirk Council area, so the eastbound off-ramp from the motorway would be on land which is currently in the Falkirk Council area. But my understanding is that that land is reserved for a motorway junction in the Falkirk local development plan. Hopefully Steve will be able to confirm that for me. But as you know, it's a matter of geography and political arrangement, isn't it? That it's a different local authority area. It's a single planning problem which we're trying to resolve, and the respective local development plans recognise that problem.
I'm good to hear what the appellant say in closing submissions. The only other thought that's in my mind, and Mr. McLeod may wish to come back on this, is thinking about the respective functions of the authorities. It does seem to me that it's where the appeal site is located is the one that's the primary determining factor. The land, because it's a Section 75 agreement, you know, that has impact on other areas of land. It's like, you know, often a kind of cross reference to other areas and other parts. But if you've got a planning site within West Lothian, where the principal application site is in relation to West Lothian, then they've got the function of deciding that. And that's the kind of the primary answer. The impact on other areas of land, which might well, in this case, partly be out with their area, it does seem to me to be slightly secondary to the primary question as to whose responsibility this is. I think Mr. Lovell has his hand up, then Mr. McCorriston.
Yeah, I just wanted to confirm that there is a proposal in the local development plan which specifically reserves the land within the Falkirk boundary, and also references the reservations in the West Development Plan, which sits funded. That's what
we can't hear you, I'm afraid.
I'm sorry, is that better?
That's better, yeah.
Right, I'm sorry, I'll try and do that again. Yeah, it was really just to confirm what Mr. McCorriston said. There is a proposal in the Falkirk Local Development Plan. It's an Appendix 1 to that plan, and it's references IN01. And it talks about N9 Junction 3 improvements. And it says in the comments box, existing safeguarding carried forward from the LDP1, that's a Falkirk LDP1, land safeguarded for northern part of new west-facing slips. Southern part safeguarded in West Lothian Local Development Plan. Upgrade will have to be developer funded. So that's the direct lift from the Falkirk plan.
Thank you.
And so just to add to my earlier response, I'm again just having some difficulty accessing documents quickly, but from my recollection, the relevant circular that deals with this makes specific reference to cross-boundary issues. I can try and find the reference to that, but I think there's a a specific reference in there that recognises that in some circumstances, cross-boundary issues will have to be addressed through the developer obligation process.
Okay. It's more generally the case that if a planning application, and now we're not at the planning application stage, has impacts on more than one area, there are calling powers for Scottish ministers. Obviously, weren't exercised in this case, but there are other provisions that deal with implications beyond the immediate council area. I think we've probably covered enough of that, unless Mr. MacLeod has further thoughts he wishes to express on that issue.
No, I'm happy to deal with the points in more detail in submission.
Yeah.
But I think just my initial response to your comments are about the potential for contributions to be made towards things out with a local authority area. In principle, yes, but one would expect in that situation to find that there had been an impact on the other local authority area. So, you know, it's not uncommon for large applications where a neighbouring local authority says, hang on a minute, the amount of traffic that you're going to generate means that we need some infrastructure upgrades here. And in that situation, there would be a mechanism found to deal with it.
Yeah.
What we have here is a situation where this local authority says, well, they say they rely on a policy in their development plan. Policy INF1 says infrastructure requirements are identified in Appendix 2. There is none for this site related to the slip roads. Further details are to be provided in the supplementary guidance, which never got past Scottish ministers, and the action programme, which we discussed yesterday. Any related planning obligations will require to meet the policy and legal test set out above. And proposed sites for new infrastructure, so the new infrastructure the local authority says we should contribute to, proposed sites are listed in Chapter 6. Now, as I said, that is very obviously within West Lothian Council's area only. So it's an unusual situation, sir.
Yeah, it is indeed. I'm sure to all of our delight. Okay, well, just moving on now to item 2.13, and this is the relevance of the A801 appeal, POA-400-2010. Before I invite comments from parties on the relevance, I've deliberately, as you know in the agenda, separated out the west-facing slip implications from the air quality implications. Now that is without prejudice to the fact that the council argue that these are inherently interconnected and can't be viewed separately, certainly not least in terms of the overall policy justification for it. But in terms of the detailed justification, which is part of the issues we have been addressing, I would like to separate out the relevance of that case in relation to the west-facing slips from the relevance of the case in relation to air quality, because we heard yesterday some of the air quality evidence. We'll get to this later in the agenda. Is arguably closer to the A801 case than the west-facing slip arguments are, but we'll get to that shortly. So I'll start with Mr. MacLeod. I have your comments in relation to that case. I'm aware of it. The council indicate that the factual context is rather different. That was a case in which the appellant successfully argued that there'd been a change of circumstances and that the council could no longer continue to justify the contributions, if I could put it in short. But I wonder, Mr. MacLeod, first, is there anything more you specifically want to say in relation to what I should take from the A801 case?
No, thank you. No, thank you, sir. I think our position is set out in writing, and quite happy to rely on that.
Okay, and Mr. McCorriston or Mr. Alexander?
I'm certainly of a similar view, unless Mr. McCorriston has anything further on that point, that we have set our position in our written submissions.
Yeah, one thing, sir, that might be of interest, given what we're talking about in relation to Linlithgow. So the council's position is set out in the response, which is essentially there was a change to the traffic flows on the predicted traffic flows on the A801, which meant that the case for dualling the A801 was less clear. It wasn't entirely removed, but was certainly less clear. One of the things that we didn't put in the statement there, as a matter of fact, is that the reasons that the traffic flows on the A801 were less was because junction 4A on the M8 had been constructed in the period between the base work being done for the A801 and the appeal being submitted to us. Now, the impact of junction 4A on the M8 was to take some of the traffic off of the A801. It effectively gave a different circulation route around the town of Armadale. The significance of that, sir, is that like the motorway junction at Winchborough, junction 4A was fully developer funded. My understanding is it was the first fully developer funded motorway junction in Scotland. I may be incorrect on that, but certainly one of the first. So we've got a fully developer funded motorway junction 4A on the M8. We've got one on the M9 at Winchborough, and there may be some relevance there to the position at Linlithgow junction 3. Thank you.
And I don't know if it's McLeod, what you want to say anything further in response to that?
I don't think there's any relevance at all in what Mr. McCorson said.
Thank you. Moving on to item 2.14, and this is the appellant's consideration that what's described as the layout selection is excessive. There's one observation and one question for the council I'd like to pose before I ask Mr. Snedden and Mr. McLeod to elaborate on the points arising here. That is that, and my reading of this is that the issue about the layout selection and the choices to be made by the council are in this case quite heavily dependent on the council's suggestion that the funding of the road is 100% funded by the developers. Now, Mr. McCorson earlier this morning has made clear that that's for reasons to do with the index linking, that it's actually ultimately going to be slightly less than 100%. I've not overlooked that particular aspect. It does strike me that at a general level, decisions as to the nature of infrastructure improvements, and that could be roads or other infrastructure improvements, you'd expect that to be primarily a matter within remit of the council themselves to make their own decisions as to how they expend their money, their policy priorities. And of course, the council are ultimately responsible to the electors of West Lothian on the decisions that they make. So the kind of the range of options that a council would have in making decisions, in this case about infrastructure improvements, I would have taken that the starting point of that would be that would be very broadly within the kind of remit of the authority, unless it could be suggested that it's out with the range of reasonable or proportionate responses, and that may well be the appellant's case. The reason I say that at the beginning is to just indicate my initial view of that, but that the scenario here might be different because the council is seeking 100% of the contributions. So if the council were seeking a relatively small percentage of the contribution, then it might be said actually the views of appellants, of developers, might have less weight because the council are paying the vast majority of the cost of the road improvements. But here, where they're seeking up to 100%, whatever that defined figure is, there is something to be said for appellants such as as the current appellants and those others on the 6 sites who are effectively picking up the tab for the building of the road to ask these questions. So I just make that point. It does seem to me there's an interrelationship between the size of the contribution sought and the extent to which this issue is appropriate for me to examine. As I say, my starting point is you wouldn't normally expect, I think, a planning reporter or indeed an appellant to be able to determine or dictate council policies on what sort of road to build. But the scenario might be slightly different here because of that kind of percentage. So I wanted to say that by way of a kind of general introduction of where I am on thinking about this issue as an opening comment. Before I go to Mr. Cloud, I was going to just ask the council transportation witnesses, just first of all, just to give us an update on what the current thinking is in relation to the nature of the nature and extent of the junction that's proposed in this regard. The appellants make the point that the information was developed, I think, either 6 years ago or 6 years in advance of the LDP being developed. And it may be useful to set a context of this is to just allow us all to be updated as to the current thinking as to what sort of junction and the nature of the junction that's now proposed. Mindful, of course, is if the junction ends up being different from what was originally planned and too much money is brought in, as the council said already, there are repayment provisions if excessive amounts of money are brought in. But it might be useful, just given the point that was made, assuming the council accept this point, that the initial decision on what sort of junction, what sort of slip roads would be built is quite old information now. It might be better to start with the council officials to explain what the current thinking is as to the nature of the junction.
So maybe I can start with that. Sure. I'm certainly not a transportation engineer, and transportation engineers on the call will be much better placed to answer the specifics than I can. But as a senior officer of the council, the council has no interest in building infrastructure above the capacity which is required, reasonably required, or spending more money on infrastructure than it absolutely has to. I'm better placed to talk about schools than I am roads, but we recognise that it's not just the capital cost of building the infrastructure, the school, it's the revenue cost of running that over the lifetime of the infrastructure, the revenue consequences will be greater than the capital cost itself. The initial capital cost is the problem, but there's an ongoing problem there. So everything that the council does is about minimising the cost, both upfront and in revenue terms, ongoing in terms of providing that infrastructure. So I think the appellants and yourself, sir, can rest assured that if there is a cheaper solution which is safe and appropriate, then the council will be happy to adopt that. I would set all that in the context of this is a piece of Transport Scotland infrastructure, so ultimately they will be responsible for the revenue consequences, and they will ultimately be responsible for defining the infrastructure itself. But absolute assurance from the council that if we can work to minimise the costs, then that's absolutely what the council will do.
Okay, thank you. Whether Trista Victoria wants to come in if and give an update on current thinking.
Yes, sir. I totally agree with what Mr. McCorson has been saying. As far as excuse me, as far as discussions with Transport Scotland have gone regarding slip roads, there has nothing. We have not approached Transport Scotland to say that we're going to be going ahead with this route, because obviously until we get funding, wherever the funding is coming from, I'll say that there's there's little point in speaking with Transport Scotland about it. The plan that we have, the plan that shows the slip roads with the 2 mini roundabouts on the top of it, was done was done by a previous developer that was looking at developing the Boroughmuir site near just to the east of the Sun Microsystems, and that they had got involved. They had preliminary discussions with Transport Scotland and had got to the stage of approval from Transport Scotland in that the context was that the layout was acceptable in pre-application standards, and that things may change when they go into the actual the full detail of it with the Transport Scotland design teams. But that the road is designed to the design manual for roads and bridges specification, and that as whatever the minimum that we can get that we're able to provide as far as the slip roads goes, that meet that Transport Scotland are happy with. That's what we would be putting in. We would be putting in a dual 2-lane down approach if it wasn't. If there's no justification for it. So the minimum road requirement is what Transport Scotland would set the scenes for, and that since that application, since that work was carried out, we've not carried out any further works on the actual details of what it would be, because not having any funding available, there's little point. It's a catch-22 situation. There's little point in going into detailed design works until we're at a stage where we haven't got the staff time to be able to produce a shelf drawing, detailed design for it. So that's the background to it.
Okay, thank you. And the reference you made to a previous proposal that led to the development of this idea, was that the Wallace Land site that Mr. Snedden refers to?
Yes.
Or rather, the case refers to for the appellant, it's the Wallace Land.
Yes, it's the Wallace Land site, yes. Sir, that's right.
Okay, can I bring in Mr. Snedden? First of all, just to tell us in general what your views are, but also go into a bit more detail on the kind of the question of the spec in this regard. And I'd be particularly interested. The appellants have lodged the relevant chapter of DMRB, and I'd be quite interested if you could just give me the references. I don't think they're there as yet, but give me the references in the design manual of roads and bridges that you think that the proposal, as is before you, offends against. Thank you.
Can I just clarify, sir, just on the DMRB point? I just wanted to check. So if you look at the supporting statement,
yes,
went in with the application, paragraph 6.9 refers to
the table.
Design. Yeah. And I think the reference is there. So 6.9.
What I couldn't see, Mr. McLeod, was any specific reference. I saw the DMRB extra or the document that was produced, and I'd seen that table. I was just trying to orientate it within DMRB itself. So that carriageway standard, that's the extract from the design manual. Then it was just the reference to it. I just wanted to be clear.
Which table was this? Yeah. Can we take that point away, sir, and we can give you chapter and verse on exactly where you should be looking, and it may be that we need to lodge a copy of extracts just so that everybody can see it in context. If
it's
that's
contextual, but that we was shown.
Yeah. On the, I'll let Mr. Snedden come in a minute, but I mean, having listened to the responses from the council, I don't think we've got a great deal more to say. I had one question, which I think actually Mr. Nicol had answered already, which is when you look at the SISTRA report, paragraph 3.1.1 says figure 2 below shows the M9 Junction 3 west-facing slips proposal received from West Lothian Council in early 2019. Design consists of 2 new roundabouts which tie in with the existing east-facing slips, and it's that, as I understand it, which then formed the basis of the costing, indicative costing, the requirement through the supplementary guidance and so on. But my initial question was, what led the council to think that that was an appropriate junction solution for the LDP sites, as opposed to the Wallace Land proposal that it came from? And I wonder, would it be possible to get an answer from the council on that point first before Mr. Snedden comes in?
Well, if they're able to, certainly was a point I'd noted from the modification statement, that reference to Wallace Land, and that it hadn't proceeded, and this question as to whether this solution that might have been apt for Wallace Land is apt for this in this context. But I don't know if the transportation witnesses from the council are able to comment on that. Maybe just conferring meantime. I mean, part of the answer I think was given by what Mr. McCorson said. The development of whatever is needed will be developed at the appropriate time, and will be the presumably, I think he was saying, compliant with the design manual, and the minimum that would be appropriate and necessary in order to respond to the needs that arise. And presumably, although Mr. Snedden may confirm this as well, presumably there's also a degree of scope for building in future potential capacity for road usage as well. You don't just build for the past, you build for the future.
So from the council's perspective, colleagues again might want to come in, but I think you sum it up reasonably well, that the council's position is we will build what needs to be built at the appropriate time. Transport Scotland will have a very significant say on that. We have the design that was before us, the Wallace Land development, again from working from memory here, but that was for around 2,000 houses, I think. Hopefully Steve or others will be able to confirm that. So the actual number of houses that we're looking at in the town is around 600, so certainly less than the Wallace Land development, but not hugely different in terms of the overall scale of the town. Less than half, I accept, but again, bearing in mind that we said yesterday that one of the sites that we anticipate would have 200 houses on the whole site, we got an application for 400 houses on half the site. So conceivably that 600 unit figure could go up if we can find education capacity for that. So ultimately we might not be a million miles away from the level that Wallace Land were looking at, but all set against that context of we will build what is required at the time.
Okay, thank you. Mr. Nicol?
Yeah, Mr. Corson just stole my wording. Yes, it could well be, it can be taken that layout is not necessarily the layout that will actually get built, because it was done back in 2013, 2014, and the design standards changed slightly and things. So it is totally correct in that we would build whatever Transport Scotland will allow us to build as far as the slip road goes, and it has to meet the current design standards. If that's a lesser layout than what's been shown so far, then that's all well to the good. But yeah, certainly what Craig has said was is the position that we won't build. When we're assessing these ones, when we're assessing the transport implications at the start sort of things, we don't have the capacity to be able to go out and do detailed design works for everything. So we have to make high level judgments of what works may be required and put costs against them. And that's what we have done in this instance. Is we happen to have had a layout that had been acceptable as a pre-application standard for Transport Scotland, and so we went with that layout. But as said, we can't. When we actually come to carry out the works, if the works costs are less, then developers get refunds, and if the works costs are more, then that's the council has to find the cost to be able to provide that.
Thank you, Ms. Alexander.
Thank you, sir. I would just mention that this dovetails nicely with the provisions in the Section 75 itself. When you look at Part 3, and in particular Clause 2.3 there, it does make it clear that the contributions are going to be used towards the traffic improvement measures required as a result of the development.
Okay, thank you. I can see the sense in fixing this, although I don't know if it was ever described as this, as being a kind of a maximum, a sort of worst case scenario, and so not leading any developers into an impression that the sums, well, they couldn't go up at the end of the day, but protect the council in terms of erring on the side of caution. That said, the appellant's argument, if I understand it, is that this is 13 times bigger than was necessary, which is why I'm very interested in it. The identification of what was required was significant, to a very significant extent larger than what we needed. But nevertheless, I'm still conscious that the assurance has been given that there'll be no intention to develop beyond what is necessary. The fact that it's Transport Scotland are going to have a significant say in ensuring the design standards, and as has been referenced, there'll be a repayment arrangement if these sums do end up being paid, if the extent of road improvements costings are lower and the money yielded is more than sufficient for what's being proposed. So I guess that's helpful from that point of view. I'm still left with a sort of slight sense of quite a kind of mismatch between the appellant's position and the council's position. Although Mr. MacLeod is saying that he doesn't think he's very much more to say, but I'll maybe give him final say on that, just because, as I say, the appellant's case and the helpful responses from the council do seem to be a little bit kind of out of kilter in terms, at least, of the appellant's appeal grounds.
Yes, sir. And also in terms of Scottish Government and development plan policy, but that will be a matter of submission in due course. A couple of points in response. The evidence that you've heard in the last 5 minutes demonstrates that there is no justification for this scale of infrastructure, the scale of infrastructure that the council has asked my clients to pay £1 million towards. Mr. Alexander makes the point about the Section 75 and that it dovetails neatly, I think he said, with the provisions in the Section 75. With respect, again, what we're talking about is taking, what we're talking about here is taking £1 million from a landowner and the council keeping that for potentially a decade. The provisions in the Section 75 say that the council is to be obliged to use the traffic improvements contribution towards the traffic improvement measures required as a result of the development. And again, the evidence that you have just heard demonstrates very clearly that the infrastructure measures that the council used to calculate that £1 million contribution are not measures that are required as a result of the development. They have no relationship to it. They have no relationship to the developments more widely within the LDP. And to pick up on Mr. McCorson's point about the fact that the level of development in the LDP might be there or thereabouts in terms of the Wallace Land proposal. Wallace Land were proposing land for, in addition to housing, land for a new health centre, a 3,716 square metre supermarket with 500 parking spaces, a 60-bed residential care home, a dance studio, a 60-bed hotel, and a conference centre. I mean, that's the context in which that junction was designed. And I have to say, and I don't know whether this is the right analogy or not, this is putting the cart before the horse. The council has developed supplementary guidance based on contributions from houses towards a junction that was designed to cater for a completely different scale of development and development from out with its own local authority area.
Presuming that argument is based on the sister documentation being attached to the supplementary guidance as being part of it, because otherwise there's nothing else that says in the LDP or elsewhere what the standard of road would be. But your point presumably is the sister report is attached to the putative supplementary guidance, and that's the connection you're seeking to make.
Well, if the justification for the contribution is something different to the sister guidance and the approach taken in the supplementary guidance, I'd like to know what that is from the council. I mean, this is a point I've made before. The council says, well, supplementary guidance wasn't approved, but we can decide on a case-by-case basis. So we're just going to go back to the supplementary guidance. That's where they've picked this figure from.
Okay, Ms. Alexander?
I feel an element of Groundhog Day here, so I wonder, clearly we don't agree with the majority of what's been said, and I wonder, rather than going through my previous submission, we leave it for closing submissions, unless you want to hear the greatest hits again. I'll leave it there.
No, I understand the points and the arguments, but it's useful just to say, because this was, I mean, all the appeal grounds are interconnected, but because this was to a degree a kind of freestanding appeal ground, I just wanted to give a bit of time over to consideration of the kind of the proportionate nature of the layout selection, and I've heard on clearly what the views of both parties are on this. That's very helpful. We're actually, I don't think they're very far away from the finishing post, I have to say, but it's 2 minutes to 1 o'clock and I'm certainly getting hungry. And Mr. McLeod is waving to someone who either wants his room or has his lunch waiting for him. So I would suggest that this is maybe an appropriate time. We could take a break till 2 o'clock. And then move on. I don't think there's any, sorry, I'm just realising there's a couple of other issues about Transport Scotland and relevance NPF4, but I don't think there's anything, sorry, I'm getting ahead of myself. I didn't think there was anything particular that was arising from the last 2 items on the west-facing slips. I'll maybe give you over lunch in case you take a different view of that, but if there is anything anyone wants to say, please say so at 2 o'clock. Basically, it does seem to me that we're probably finished to a reasonable extent the issues we can talk about in relation to west-facing slips and go on to air quality in the afternoon. And as you say, just as a sort of a advance kind of notice of the afternoon discussion, we had a good going over of a number of the issues yesterday. I know there are some standing issues, including the council's general approach to the response to the questions. But again, I don't want to repeat too much of the evidence that we heard yesterday, but there are some outstanding questions I think we need to address. So if we reconvene at 2, and if anybody has anything further on west-facing slips, we can do that, but essentially try and use time then to address air quality improvements and local junctions relating to that. So I'll adjourn, if that's okay now, for an hour. It's exactly 1 o'clock till 2 o'clock. Thank you.
Thanks.
Good afternoon. I think most people are back just yet. One is too still to come, that's fine.
I'm in now.
Ian,
Thank you. Just about ready to start the afternoon session. Just before lunch, when I realised I was just getting slightly ahead of myself on the policy issues relating to west-facing slips, that we hadn't addressed issues 2.15 and 2.16 of the agenda specifically in order. Nevertheless, we have heard in the course of this morning and yesterday issues in relation to the Transport Scotland position as Trunk Road Authority, and I think the position on NPF4 has been set out before, but I said I'd give opportunities to parties, and I'll start with the appellants, give opportunities to parties to indicate if they wish to say anything on those two items. I think we're moving on to the air quality improvements issues. So start with Mr. MacLeod.
Thank you, sir. Really just one comment to make, and it arises from the evidence that we heard just before lunch. So you'll see that the Council's response to 2.16 is that the Council's position is that the infrastructure is essential to support the development in the town, and the issue cannot be resolved in any other way. Now, I think, based on the evidence you've heard this morning, that is not an accurate statement, because what the Council seemed to be saying before lunch was, effectively, it was very unlikely that they were going to build the slip roads that were set out in the Wallace Land proposal. They were saying that they would do something else in due course. It would be based on whatever designs or design standards were appropriate at the time. And there is one further point with that, which is, would policy actually allow for it now? I mean, the proposals were conceived of at a time when motorway junctions were perhaps more common. I'm not clear, and we don't know because the Council hasn't spoken to Transport Scotland more recently than the supplementary guidance. But I don't know, sitting here today, whether from a policy perspective, Transport Scotland would still countenance a motorway junction when one considers matters such as the drive for net zero, etc. And I'll just make one final comment, which is, and it leads into the air quality issues, that there are, as I've mentioned, a range of air quality actions that the Council was recommended to investigate, many of which do not involve the construction of anything. They're about enforcing parking, doing traffic management measures within West Lothian, within Linlithgow High Street. And it's not clear to me whether the Council has ever investigated those and considered whether they could bring about improvements in air quality. I had hoped that some of their responses to your questions would have enlightened us, but they have not.
Thank you. Mr. Alexander.
Thank you, sir. I'm sure our transport officials will want to speak as well, but my sense of our discussions before lunch was that obviously this is a process that needs to be gone through in more detail. As it stands, we have the slips which are included in the current LDP at Chapter 6 at page 88, which the development table includes the M9 slips from a policy perspective. But the fact of the matter is that design and delivery processes do need to go to be gone through. And I think that was my take. It wasn't a case this will never happen. I didn't take that at all from what we were discussing prior to lunch. What I took from it was that this is the council's option to progress at the moment, but there's other steps to take, understandably, given that it's on a motorway and Transport Scotland and what have you. But I'll perhaps offer any further comments from the team if that's...
Yeah, if you could bring in transportation colleagues to answer that point. I suppose that the one thought that came to mind listening to Mr MacLeod is that Transport Scotland, I don't know how long ago, but certainly had approved Junction 1B, but things may have changed obviously even since they approved that. But if anybody has any up-to-date information in relation to Transport Scotland's policies as impact on this, the aspects of the net zero issues raised by Mr MacLeod, certainly that would be useful.
Yeah, so again, transportation colleagues will assist, no doubt, but I'm not aware of any evidence before you to suggest that the position of Transport Scotland has changed. I'm not sure if the appellant has lodged any such information. I'm certainly not aware of that. So the position from the council remains that the most up-to-date position from Transport Scotland was the consideration as set out earlier on in terms of firstly the local development plan and more recently the Wallace Land proposal set out. Just in addition to that, sir, I think Mr MacLeod there made reference to the council's supplementary statement on paragraph 2.16 or in response to question 2.16, saying that he thought I can't quite remember the wording that Mr MacLeod used, but suggesting that the intervention, because it was of a different design, was no longer required. Just to be absolutely clear, sir, that the intervention or an intervention is required, whether it should be described as the intervention or whether it should be described as an intervention which results in all waste slips at Junction 3 is the council's position. So it might not be the intervention which is set out in the at various places, not least the Sistra study, but an intervention to relieve the high street is required.
Okay, thank you. I think in fairness to Mr MacLeod, he wasn't actively suggesting there has been a change. He was simply asking the question as to whether, given the passage of time, whether that we know whether or not there's been a change, but perhaps transportation colleagues can answer that question.
Thank you, sir. Yeah, we would, just as Craig said, there's no change in the previous. And I think the only thing that we could sort of add is that I understand the comment about achieving net zero, but putting infrastructure in to support the development's not necessarily the way to achieve that. And there are other ways that could be done via, mode of transport and that sort of thing. So I think on that front, that doesn't seem like a reasonable comment.
No.
Okay, that's fine.
Just to indicate, so I'm may come as a surprise to Ms Mungle, but I'm actually in agreement with what she's just said there, because the point is this: the council says that the issue, and as I understand it, the issue they're talking about is air quality within the town centre. The issue cannot be resolved in any other way. Now, Mr McCorson said that what he's talking about there is effectively western slips rather than that particular design, and I take that point. But what Ms Mungle's just said is that the issue may be resolvable in another way. For example, improving modal share. And again, we'll come on to discuss this in the context of air quality, but there are a range of measures that the council has had recommended to it that would not require the construction of western facing slips and may improve the air quality situation. And I just want to be absolutely clear.
when the council says that the issue cannot be resolved in any way other than western facing slips, where is the analysis that shows that is correct and that non-physical interventions cannot deliver the objective that the western facing slips are intended to deliver?
Victor Mungo's got a hand up in response, presuming to that.
Yeah, I just wanted to chip in to say that air quality is one aspect, but the other two factors that we need to consider is travel time, which is clearly set out in the tables in the SISTRA report, and also congestion within the high street. So it's not necessarily just the air quality aspect that's the issue here. It's resolving, the other two problems as well.
Mr. Alexander, do you want to say anything about this specifically in response to Mr. McLeod's question, or bring in a witness who is able to?
I can see that Mr. McCorson has his hand up, so I'll perhaps let him speak first and then perhaps follow up after that. Thank you, sir.
Again, I'm obliged, sir. So, we've set out, the council's set out that air quality is a consequence of traffic impact, or at least partly a consequence of traffic impact, not least the stop-start nature of traffic along the high street. The SISTRA study sets out that that will get worse if there are no interventions, and they don't get worse if there are not all the interventions and just some of the interventions as we've set out. But the facts of the matter are that the application sets out that 55% of, or 58% if you accept my assessment of it, but let's go with 55%. 55% of the trips from this side will be by private vehicle. We can certainly encourage different approaches to that. Hopefully some of those will be by electric vehicle, which will no doubt have an impact on air quality in the town, but it's still 55% of traffic movements from 60 large houses will be by private car. That is the issue. Those are the vehicles that will traverse up and down the high street at the level identified by Mr. Snedden earlier on, or indeed above that, because those were only the peak time figures for movements. There will be significant movements along the high street throughout the day from this site, not just during the peak, and that is the issue which has to be addressed.
Okay, thank you. Unless anything else from Mr. McLeod.
If I could maybe repeat the question through you, sir, because Mr. McCorson studiously avoided answering it. And the question, just in case you missed it, was, where is the analysis from the council that the issue on the high street cannot be resolved in any other way apart from the western facing slips? What document shows us that?
Sir, happy to respond to that. In terms of the transportation interventions, I will accept Mr. McLeod's point that potentially there are other solutions. The Lithgow Planning Forum sets out some additional solutions. Those solutions all require significant infrastructure investment, and indeed the planning forum's interventions require interventions way in excess of the motorway junction itself, the cost of which would be very, very significantly above those which we're discussing here. So I accept it's not the case that there is only a single intervention. There is only a single intervention which is costed a deliverable and part of the local development plan.
Anything further on that?
Well, again, I think Mr. McCorson hasn't quite answered the question. and it's not my fault for the way that I've put it. What I was trying to understand is, has the council given any consideration to non-physical interventions? And I've mentioned the air quality action programme, so that looks at things like improving parking enforcement, ensuring that cars don't idle and stuff like that. And what I was trying to understand is, council's case to this hearing seems to be predicated on there's a need to improve things in the town centre, and the reason for that is primarily related to air quality. The council says in its response, the issue, which I understood to be air quality, the issue cannot be resolved in any other way apart from the western facing slip roads. And what I was trying to understand is, has the council done any kind of analysis of non-physical interventions, such as improving parking enforcement, preventing people from idling, trying to increase mode share as suggested by Ms Mungle earlier on? Has the council done any of that analysis? It doesn't sound like it has.
I was inclining initially to think whether Mr. Carmichael may be able to comment on that, but Mr. Alexander's put his hand up, so I'll bring him in first.
Thanks, sir. I suppose just to clarify what the issue is, which I think is incredibly important, and what the Section 75 agreement does is collect contributions towards traffic improvements, which will be used to facilitate traffic improvements to the high streets. Now, the improvements that are needed are the volume and speed of cars. Now, one of the resultant benefits of that will be improved air quality as well. I suppose the point is, the reason isn't air quality. The reason is traffic improvements, traffic flows, volume and speed, which also has an additional material consideration improvements on air quality as well. So I think it's rather, to solve that problem, traffic, you need perhaps a more significant infrastructure required, which is of course outlined in the sister report, in that we need interventions that will have the resultant effect of improving the high street.
Mr. McClure leafing through documents, looking for a reference to something, so he may have a further question.
Well, there were 2 points. One was that, and I can't find the reference at the moment, but we have had it earlier on. You'll recall, sir, that I think it is the sister report itself that says that junctions within the town are not at saturation levels.
Yes.
So my understanding was this was not a traffic capacity issue as such. This was an issue of problematic driving within the high street that was causing an air quality problem. And I had understood that the end point, the thing that the council really wanted to solve here, was an air quality issue rather than a traffic issue, which its own consultant said was not at saturation levels. So that was the point I was looking for. But I'll try it again for, I don't know if it's a fourth or a fifth time now, but has the council looked at non-physical interventions as a means of solving the air quality problem or issue? And let's just to try and put it as neutrally as possible for the council, let's assume for the purposes of this question that the air quality issue may be just one of some that the council wants to solve. But when it comes to the air quality issue, has the council looked at alternative measures to solving that other than the western facing slip roads?
Okay. Mr. McCorriston, but maybe Ms. Alexander might go on to comment after on that. But go to Mr. McCorriston first of all. You're on mute.
Apologies. You think after 3 years of working
with
there's
always to have to somebody.
Yeah, so apologies for that. Yeah, so I think essentially Mr. MacLeod is trying to conflate two issues. We've set out on a number of occasions. I'm not sure I can set it out any more clearly, but the issue in the high street is traffic, and it is the traffic that creates the air quality problem. Now, we can seek to address the air quality problem, and there are ways of doing that, which I think is what Mr. MacLeod's question is, but that will not change the position with traffic on the high street. So, for example, Mr. MacLeod talks about, have we looked at addressing indiscriminate parking? Well, of course, that's not a function of the council. That is a matter for Police Scotland to address illegal parking in the high street. But if we solve illegal parking or indiscriminate parking in the high street, it doesn't actually change the volume of traffic which is going up and down the high street, which is the problem. So it might have a consequential impact on air quality, but it doesn't change the position with what is the fundamental problem, which is traffic in the high street.
Okay, thank you. I'm conscious that we've moved into the afternoon's representations on air quality, and I wondered actually, before we get any further into that we're into just now, I wanted to raise at the start of this part of the hearing. Parties may be aware I've certainly had an email that has gone to my case officer from Vary Foy. I don't know if Mr. MacLeod, you've seen that. It's coming just over the lunch period, and what it contains, if you just bear with me a second. Hang on. It has sent to me and others, though I've not looked at it as yet. I'm just trying to get it up on screen just now. A web page from the council's the council's website, which has a series of documents in relation to air pollution at West Lothian, and says that all documents are available at the bottom of the page under the download section. Gratefully, this could be drawn to the attention of the reporter for his attention in due course. It's just arrived, obviously, over lunchtime just now. I was going to ask if the Foy wants to say anything further about that. It may be that the provision of this information follows from the evidence yesterday that Mr. Carmichael was referring to. Obviously, there seems to be quite a lot of information. I've opened the web page, not gone into any of the documents set. There's quite a lot of stuff there. And obviously, it's provided, and Mr. MacLeod may well be looking at his emails to see if it's come into him. It's obviously been provided quite late in the day, as being at lunchtime on the second day of the hearing. And I just wondered whether the council want to say something more about that, and the question as to whether that should be admitted into the process, and how, if it is, how we address any issues that might arise in relation to that. And Mr. MacLeod will get a chance to comment on that once it's heard from the council.
Thank you, sir. I think it was really on the back of yesterday's session where it was discussed, and it was really just for completeness. I think we were asked to circulate it. I think there was some misunderstanding on how to access the links. So Mr. Carmichael sent us the link, which we sent on to parties. Now, it's on no more or less a basis than that to facilitate that, Mr. Carmichael can speak to any issues that you might want to discuss on air quality. But I appreciate the timing is late, but I suppose it was because it came up in yesterday's session that my impression certainly was that your request was to circulate.
Well, certainly the point that Mr. MacLeod made is that in answer, I think there was a web grab that the appellants had lodged about in relation to the air quality plan that's been submitted as a document already. And I think Mr. Carmichael, in his indications yesterday, said that he'd be able to answer various questions under reference to other documents. And I think Mr MacLeod had made the point those documents hadn't actually at that stage been lodged. We never really got to the bottom as to whether what we do about those documents, although Mr MacLeod did indicate that any such additional documents he's not had notice of, and he certainly hasn't had notice of until at least lunchtime today, or at least the last few minutes. So I suppose there's a kind of procedural issue to the extent to which I've not looked at any of those documents. They're not lodged, obviously, in accordance with the sort of timescales that we were looking at for the hearing. I hear what you say, that to a degree issues arose yesterday, but as Mr MacLeod had pointed out, these were issues that have been aired for a little while in the course of a reasonable length of time, perhaps even before this appeal was taken, I don't know, but certainly during the course of the appeal, and we have had a deadline for lodging documents. So I'm going to turn to Mr MacLeod and just get his views as to what's the best way of proceeding in relation to this evidence. It does strike me as quite difficult at this stage this afternoon to expect him, or indeed expect me, to be navigating our way around documents that are not seen before. But Mr MacLeod.
Sorry, sir, can I just intervene briefly? Just so we're clear, and perhaps I wasn't clear enough there, is that it isn't our intention to rely on any of these documents. It was simply, I maybe misunderstood the course of the conversation, what you were seeking. So it was really for completeness to circulate that. We're not seeking to rely on them.
Yeah. And Mr Michael's got his hand up just now before I come to Mr MacLeod.
Yes, sir. That is exactly what I was just about to say, that I'm not going to be relying on any specifics of these documents. It was just, I thought was for completeness to highlight that there's a whole range of documents, not just the document Mr MacLeod had alluded to on the website. But I won't be referring specifically to any of these documents.
Well, you certainly said yesterday there were a range of documents, so the issue really is the fact that we now have them. But Mr MacLeod.
Thank you, sir. Well, I have to say thank you to Mr Alexander and Mr Carmichael for clarifying those points at the end, because I think that simplifies what might have otherwise been a quite difficult discussion. If the council does not intend to rely on these documents, then my submission, you don't need to have them. And you already have a document from the council's website, which I think was agreed. Obviously, Mr Alexander can come back and say, but I think was agreed was an accurate position. Now, it looks, I have literally just seen the email just now. I didn't appreciate that was going to be coming in. It does look as if there's an awful lot of information. But if the council's position is it doesn't want to rely on any of that, and it's simply providing it for completeness, you don't need to have it, sir, if the council is not making any point from it. And on that basis, I suggest that we simply put it to one side and proceed on the basis of the evidence that's been timeously lodged.
And I should say, when I got that, I clicked the link which took me to the web page, but I opened no document that was there. That was there. When I saw how many there were and realised that there needs to be a discussion this afternoon, I went no further than looking at that. So I don't know if the council have anything further to say in that respect. I think they have clarified the position, and certainly I'm content to proceed with this afternoon's agenda, because there are questions we have to address on air quality on that basis.
Nothing further from our point of view, thank you.
Okay, thank you. What I was going to say at the opening of this section is that we did have a discussion yesterday, and I think I understood the various strands of the appellant's arguments in relation to air quality improvements. I'd also seen in relation to the preparation for this hearing, and this might in other circumstances have tied in to the question about the information just lodged. The council's position in relation to the various air quality improvement questions that I'd asked is that they hadn't come back with specific answers to the questions for the reasons that they've set out Their position is the contributions sought are transport interventions which have a positive effect on air quality, and they reference do give some reference to the policy context of the local development plan policies EMG4, as well as referencing NPF4. I may start with the council before we get into some of the issues that still arise in relation to air quality that weren't addressed yesterday, as to what their intended approach that I should take to the air quality issues is. And we've touched on some of that already. In some ways, reflecting on this, even before the conversation we've just had around the interventions, is I have a slight feeling, or had a slight feeling in the course of this hearing, that when questions are asked about air quality, the answer is transport improvements at the west-facing slips. When questions are asked about west-facing slips, the answer is air quality. So I need to really go back and kind of properly understand how these two aspects of the council's case interact. But I'll maybe start either with Mr. Alexander or Mr. Carmichael. Mr. McCorson may want to comment as well, just as on the generality of the council's approach to this section of the hearing today, in light of their general response of saying, as I read out part of it a moment ago, that these aren't issues that needed specific answers to the questions at 217 to 226 of the agenda. We start with Mr. Alexander.
Yeah, thank you, sir. I suppose we've talked a little bit around it already. I suppose the council's position is quite clear that a package of works are required. So the west-facing slips and the Linlithgow junction improvements, they're needed and they're dependent on one another to ensure that new developments in the LDP can come through and they do not increase the number of vehicles on the high street. Now, I appreciate it was a brief paragraph or two that we used to respond to this section of the hearing session. But I suppose the important bit is it's the transport flows, and Mr. McCorson no doubt won't say more on this. It's the impact on the high street that we're trying to resolve. And to do that, in order to release the new sites for the town in terms of the LDP, a transport solution is needed. It's a transport solution that's being collected in terms of the Section 75, and it's a transport solution that will ultimately alleviate the issues on the high street. And a consequence of that, an additional material consideration will be improvements to air quality.
Okay, thank you. Mr. McCorson, on the general level then, Mr. Carmichael, anything you want to add to that from the environmental health perspective?
Yeah, thanks, sir. Again, I'm not sure that I can add very much to that which Mr. Alexander has set out. I would maybe take it back a stage in policy terms, and you've heard on a number of occasions now in terms of the area of restraint policy that applied in Linlithgow. Important that's recognised as a policy of restraint. It wasn't a prohibition on development. It was restraining development to the environmental capacity of the town. And the environmental capacity, again, as we've set out on a number of occasions, was firstly education, but the second reference was to the environmental capacity of the high street. So it never referred to traffic levels. Excuse me, sir. It didn't refer to traffic levels. It didn't specifically refer to air quality. It talked about the environmental capacity of the high street. But that became translated into traffic volumes and associated air quality with that. We accept as a council that air quality was a bigger issue in the past because the vehicles were less efficient as they are now. We can't, I mean, we've never said in any of the conversations about the reduction or the improvement in air quality about the impact that COVID has had, because we've had a significant reduction in traffic volumes. Are now returning to where they were, but that will have had an impact on air quality in the high street. But whatever way we dress this up, sir, it comes back to the fact that air quality is at least in part a consequence of traffic volume, probably in our case, and Mr. Carmichael will be able to say a lot more than I can, but a very significant proportion of the air quality issue in Linlithgow is a result of traffic volumes, and that's for the reasons that you've identified yourself, sir, and also the planning forum have identified that the high street performs a number of different functions. It's a through road, it's a retail frontage, it's a residential frontage, but it's also a particular shape of high street, if you will, and the air quality issues often referred to the canyon effect of the high street. Relatively high buildings on either side, and the issue of stop-start traffic within that canyon of a high street. So whatever way we dress it up, and just to reiterate, it comes down to principally an issue of traffic on the high street, which causes the air quality issue. So at the risk of repeating myself again, to address the air quality issue, you have to address the traffic issue. I accept Mr. McLeod's point that there are other ways of doing it, but not many of those are within the control of the council, and they don't change the traffic volumes going through the high street.
Okay, thank you. I'll bring in Mr. Carmichael next.
Thank you, sir. Yeah, just to reiterate what Mr. McCorson has said, predominantly I would say probably most of the pollution in the Linlithgow High Street is caused by the volume of traffic which goes through it, and air quality is obviously an effect of that large volume of traffic that goes through Linlithgow. I'm not sure if you want to ask me any specifics, but generally speaking, going back to when the air quality management area was declared, and a draft air quality action plan was developed. There was a range of issues within that, and not all those issues are about necessarily reducing the volume of traffic. But there's the western slips were highlighted as potentially an option to look at in the future for reducing the volumes of traffic in Linlithgow. Obviously, events have overtaken that action plan didn't go to the finalised action plan, where there would be a legal requirement on the council to instigate measures. So we're in a situation now that the council would wish to maintain the relatively good air quality now in Linlithgow without it cumulatively resulting in a further degradation of air quality associated with not necessarily this site individually, but cumulatively with all other sites. Development that can lead to a cumulative impact that can make air quality worse. So you might have multiple small developments that, despite having a small or a negligible impact on air quality, can have a cumulative impact because they all impact upon air quality because they may increase the volume of traffic going through Linlithgow. don't know if there's anything else I need to say on that.
So on that point, just to be clear, from one point of view, are you saying that if you've got a number of sites that are each contributing a certain amount, the cumulative whole might be greater than the arithmetic total of the contributions from each site? Is that effectively? Is that a thing? Is that a potential risk?
Yeah, absolutely. And our obviously our guidance on air quality recognises that you can have small developments such as this one. This development particularly does have a negative impact, but that negative impact on air quality is very minute. It's very insignificant. But when you look at taking all the developments that come online at one time, then that could have a cumulative impact that could degrade, well, certainly will degrade the air quality without mitigation measures being put in place to avoid an increase in traffic on the Lithgow High Street.
Yeah. And that cumulative effect, is that, I don't diminish it by saying in the abstract, but is that through kind of the methodology and the science that's understood, or do you have any basis for thinking that's true in this particular context of these 6 sites, or has that not been explored?
Well, I think, sir, obviously you would have to model the impact on air quality, but we know with increased traffic we'll have a degradation in air quality. The extent of that would have to be modelled as far as looking at that scenario.
Okay. Thank you for that. You asked if there's any further questions. I'm going to ask you 3, and then I'll go to Mr. MacLeod and allow you to wrap up on the generality. Then we can move on to more specifics. And the 3 questions that are in mind are actually the ones on the agenda. And just to record your answers for this. First of all, to what extent are the air quality improvements already needed, regardless of the development of the sites or otherwise sites identified in the LDP? That's the first question.
Well, there's the issue of Lithgow being an air quality management area where improvements are required if it remains an air quality management area under local air quality management. But notwithstanding, if it wasn't an air quality management area, the council still, considers air quality to be enshrined into planning development to ensure that air quality is maintained or indeed improved, and so those matters would be separate, not necessarily maybe separate from the air quality management area regime, but that is the council is determined to avoid developments which have a negative impact on air quality.
Well, the reason I asked that question is we had a little bit of a discussion yesterday, and I understand the council's point. It's in the discussion we had about the traffic infrastructure, transport infrastructure improvements around Winchborough and the comparison with Lithgow. And we got into a bit of a discussion as to whether, to what extent, what's required in a transportation sense is a tipping point or not. I'm not going to reopen that. I suppose applying the same question to the air quality improvements and the associated traffic improvements on the high street, whether, as far as you're concerned, the need for the traffic junction improvements along the high street and the associated air quality improvements, is that a similar tipping point argument that you don't need them right now, or you didn't need them prior to the Mance Road site being given consent, but if these sites were given consent, then that's what requires these improvements to be made? So do these sites create the problem, or do these sites exacerbate the problem?
Well, obviously, I think the sites create a cumulative problem that has an impact on air quality. So, if these sites did not go ahead, there would not necessarily be a degradation in air quality in the Lithgow, because we're not adding significant traffic to the high street. But we need to consider the developments in the context of the transportation side into what sort of numbers of vehicles that might add it to a high street in order to determine the impact on air quality and how significant that impact is.
Thank you. A couple of other questions, but Dr. Kelly's got his hand up just now, perhaps in relation to that specific point. So I'll bring him in now, Dr. Kelly.
Thank you. Yeah, just on the subject of air quality in the high street, and we've talked quite a bit today about the difference between traffic management issues and infrastructure improvement issues. And in fact, the air quality action plan 2017 has got 26 different options, of which the M9 slips are but one. Some of those are traffic management options, and some of those are infrastructure options. I also note from the local development plan that traffic management measures in the town centre are to be actioned under P115. That's on page 88
Yes.
of the local development plan. But to date, nothing has occurred. It's also, I think, important to note that many of the traffic management issues have been suggested before. In fact, there was a very good report done by Halcrow Fox in March 1992, which would have resolved quite a large number of the traffic management issues. It still is the case that from the Halcrow Fox days, the amount of traffic going through the high street has almost doubled, and the impact of further sites, further development within Linlithgow will obviously increase that traffic. Just wanted to make sure that everybody understood that these issues have been going on for a long time and have been recognised in the local development plan and the air quality action plan for a long time as well.
Thank you. I'm grateful for that altogether. I know that somebody, I've now forgotten who, had referred me to the P115 reference yesterday. So thank you for the reminder in that respect. The second question from Mr. Carmichael, it's just an opportunity to comment if you wish to, was on one of the questions at 2.20. One of the documents that is lodged is the 2018 Council Air Quality Guidance, and since that is a document before us, I give you the opportunity, if you want to, if you feel there's anything you want to draw my attention to from that document.
So you're referring to the planning guidance document?
It's the air quality guidance.
2018, yeah. That document really sets out, how the council will approach air quality and air quality impact assessments when for developments that fall within different categories, particularly in an air quality management area. As part of that document promotes, the idea that the council actually states within that document, the council is determined to avoid development leading to a gradual worsening in air quality due to cumulative impacts of numerous small developments. So the whole basis of that document is not just to consider what exists now, but in the future from other developments and the sort of mitigation that might be required in that.
Thank you. That's helpful. I think that's probably the kind of specific questions. I'm going to go back to Mr. MacLeod. Well, I'm going to come on to what I regard as the only outstanding questions for me, which are questions 2.22 and question 2.23, dealing with those just separately, and I'll ask Mr. MacLeod some questions about that in a minute. But just in terms of the responses on the other aspects of air quality from Messrs. Alexander, McCroston and Carmichael, I just pass over to Mr. MacLeod for any responses or further observations on what's been heard in this section of the evidence section, or indeed what Dr. Kelly said.
Very little, I think, sir. I did have a question about the air quality action programme that Mr. Carmichael mentioned earlier. And Dr. Kelly mentioned as well, I think from his evidence, there are 26 different options. And it goes back to a theme that I raised earlier on, which is, what's the council done with that? You know, if air quality is such a serious issue in Linlithgow, what has the council done about it?
I don't know. If the are able to offer a response to that.
Yeah. So I can certainly offer a response to that. So the whole issue of statutory air quality positions is a separate legal process. There's legislation which deals with the management of air quality. Excuse me yet again. There's a separate legal process which is involved there, and the council has certain duties under that legislation. As Mr. Carmichael has said, if the council formally designates an area and then approves the action plan as part of that, and he will keep me right on the precise detail of that, but it then places a duty on the council to act. Now that is a duty to intervene, and inevitably those interventions come at a cost. Now it is hopefully of no surprise to anybody in the virtual room about the extreme financial position that councils find themselves in at the moment, not only in revenue terms, but in capital terms. And the council's position at the moment is that given significant financial cuts, budgetary cuts, which it is dealing with, that it has difficulty maintaining the existing estate and the duties which it has to do before it starts to take on additional duties. So any commitment that obligates the council to carry out capital investment, which is unfunded capital investment, has to be taken very, very carefully, and it is for those reasons that it has been slower than it should have to progress many of the interventions which are identified, but it is simply a recognition of the financial position that not just this council finds itself in, but pretty much every council across the whole of Scotland. Brian will correct me if I've got any of the legislative provisions wrong there, but that's the financial context in which the council has to operate.
I don't know if Mr. Carmichael wants to say anything. Yeah.
Thank you, sir. Yeah. My only comment on that is when we're talking about the air quality action plan, that is a draft action plan, and it remains draft at this moment in time. For various reasons, it didn't go forward to the final stages of that. Normally what happens with an air quality action plan or a draft is that you look at a range of measures that might assist in reducing the air quality. And the second stage of that would be then to have a carry out a cost benefit analysis of all those measures in relation to the reduction in air quality. And we haven't got to that stage of that. And the detailed assessment was only really completed last year, which supports moving down a different path as far as local air quality management in Linlithgow is concerned.
Okay, thank you. Those issues and those questions and those just earlier, actually, it leads me a wee bit, I think, dig into this slightly out of order to agenda item 2.23, and this is the analogy with the 881 appeal, POA 2004. I said this morning that I thought there may be slightly different considerations coming into play. The reason I said that is linked with Mr. Carmichael's last answer and the evidence from Mr. Snedden yesterday supporting the idea that there have been improvements and things aren't as bad as perhaps they once were. The issue arising in the AA-1 appeal, I think, was a change of circumstances, obviously a transportation change of circumstances. The essence of the case there is that the council hadn't stayed up to speed with the consequences of those changes. Mr. McCarson explained what the changes were because of the M8 junction. And I guess in that sense, that's partly what the appellants are saying here. It's in air quality and things have moved on. But the consideration of the applicability and appropriateness of the obligations not moved on. So I suppose my question, I'm going to start with Mr. MacLeod, just to partly tell me whether I probably kind of understood the read across to that case, whether there's anything from that is of relevance or assistance on air quality, and then go to Mr. Alexander for his response on that point.
Very little to say, sir. I mean, the case was originally lodged as part of the appeal simply to demonstrate that sorry, somebody's calling me on my Teams there.
Oh.
Apologies for that. The appeal was originally lodged simply to illustrate what had happened during the evolution, if I can put it that way, of the supplementary guidance, and there wasn't really much more to be taken from that. I think the analogy that you draw is a fair one. In the AA-1 case, the supplementary guidance was prepared on a particular basis, evidence moved on in relation to traffic, and it does seem that the same has happened in the context of air quality in this case. Beyond that, there's not an awful lot more that I would want to say about that case, I don't think.
Thank you, Mr. Alexander.
So yeah, I broadly agree with those comments. I suppose the critical point here is that the council are in a position of ensuring that 624 units can be accommodated on the high street, and that goes back to points we've discussed over the last couple of days, and that is the problem. That is the problem that needs resolution, because what we don't want on a cumulative basis is, and I'm sure the Civic Trust would agree with this, we don't want 624 units coming online and there's absolutely no mitigation in place, which appears to be the appellant's position that nothing should be payable towards transportation.
Okay. On the basis that there's a policy justification and an evidential justification, thank you for service, MacLeod. You want to comment on that? I was going to move on to the next point, but you wanted to say something more.
Just a very brief response to Mr. Alexander. The appellant's position is that the evidence does not justify the contributions that have been sought. The council's evidence this afternoon has been there was a problem with air quality, and we were given a draft range of solutions, but we didn't adopt that plan because it would have had financial consequences for us. And I understand the difficulties that West Lothian Council may have from a funding perspective, but with respect, that is not sufficient justification for asking the appellants to solve those problems. The council has legal duties, and the legal duties under the 1995 Act, and again, this will be a matter of submission having heard what I've heard, the legal duties under the 1995 Act are not restricted by reference to the council's budgetary concerns. If the council feels that there's an air quality issue that needs to be resolved, it has a legal duty to deal with that. What seems to be happening here, sir, is that the council has a financial problem that it believes prevents it from delivering its environmental duties, and it has sought to resolve that problem by asking a number of developers to pay much more than they should have been asked to pay to resolve that existing problem. So I feel it's important that I get that message across. It's not that the appellant says that they shouldn't be paying anything. It's that the appellant says that the evidence does not justify what the council is asking for at all here.
Okay, thank you. No doubt you and the council will elaborate on that in closing submissions. Where I was going to go to next was on the basis that it's shown that there is a policy justification for these improvements and that it's rational that the obligations should be imposed on a range of sites, including this site. The next question, which is really identified at 2.22 of the agenda, goes on to the question of what's the evidential basis and the justification for the proposed obligations as intended by the council, which, as we say, would cover the whole of the £453,000. It goes back to the LSIC question of causal link. So I suppose the question that I'm asked for the council first of all, maybe from Mr. Alexander to answer first of all, is questions of what is the causal link, and what is the justification for the sums that are sought? Why is it that the full amount is paid for in terms of these particular developers? And again, tied with that, if 100% is not the right answer, which is certainly Mr. McLeod's argument, he says 0 is the right answer, but assuming that something is the right answer, what do I need to make of the evidence to try to find a way to the right answer? If Mr. McLeod is right that 100% is not the right answer. There's quite a lot in that, but the questions are all related and interrelated.
Yeah, thank you. Ultimately, the position is very similar to the position we discussed in the previous section, because the council's position, which is hopefully clear, these package of interventions can't be looked at independently to solve the problem. So we can't take the west-facing slips in isolation. Equally, we can't take the town centre traffic management measures in isolation. But together, and this is what the council's position, in order to release the 9 sites for Linlithgow, there needed to be a solution to the high street. The council now have looked at, in terms of, we've talked about it in terms of the LDP, the action programme, the sister report sets out, when the council determined the application, what sums would be sought for sites developing. And they've based that on the 9 sites coming forward, the 624 units. The practicalities of development management mean that it's 563 units which haven't been consented for, and they're the sums that are being attempted to be secured by the council to ensure that there's infrastructure that allows development for the town without major impacts on the high street from a transport perspective. So the position is the same for this, the town centre traffic management interventions. The 473,000 is exactly the same for the 8.5 million for the west-facing slips, because the issue is the same. The issue is the high street and how you alleviate that.
I get the 560 houses, and I get the 6 sites, and appreciate that. One of the differences that struck me is the sister report. Now, the evidence this morning from the council in looking at the questions that were posed by Mr. Snedden were of a more general nature and weren't really based on the kind of the specificities in that particular report, but at least the transport and the issues around the west-facing slips, at least they have the sort of an evidential basis in the sister report, albeit one criticised by the appellants. But at least there was a basis for that. What I'm kind of struggling a little bit with the transport improvements of the high street, the air quality improvements, smaller sum though that is, what we're struggling a bit is working out how it can be justified that these particular sites should take an equal share of a percentage that's as high as 100% of the consequences of these improvements? Is it another variation of the tipping point argument? Is there empirical evidence that supports that? You know, what's the basis for saying that the rate should be 100%? I understand the point that has been made, that it's split equally amongst all the houses on the 6 sites, 563 in total. But I'm just looking for a little bit of guidance, if there is any to be had, and if your position is that there's no guidance to be had, it's just the right figure, then that's the case. The council, but I'm just wondering, is there anything that I can look at and identify that tells me how can the 100% figure be justified, and if not, what would be the right figure that would be justified in relation to air quality improvements?
Yeah, I mean, the position is that the justification is in the LDP and the reason why the area of restraint was lifted. And one of the key reasons it was lifted was the environmental considerations in the town. And on that basis, the council needs to mitigate those environmental considerations. And as you've mentioned, they've decided to do that on the basis of the units generated from these newly allocated sites, which would have only been allocated in the event there were solutions to this problem, and obviously education as well, which isn't relevant for today. So that's the policy background, which I know we've talked about a lot. It was a key plank of it. That's the point, and Mr. McCorrison's, I think, said more than once that, you know, as much as he's not the decision maker, his recommendation would be for refusal if there wasn't a solution to this problem. The council, as it must look to the proper plan for the area and try to accommodate new sites for the various reasons that we've set out for affordable housing and others. But we need to ensure, when we're looking at those house numbers being released, that adequate mitigation is placed, and that is the equitable way to do it in the council's view.
Presumably, your argument is that LSIC, properly understood, at least from the council's perspective, is that doesn't constrain you from your clients from adopting the policy that it has adopted. There's no need for a causal link in the way that LSIC suggests. Is that effectively what you're saying?
Well, no, there is a causal link, and that's the critical point, because different to LSIC, where we've got a much larger area, we're talking about a town. Specifically, we're talking about a high street in the town. And we're talking about a town that needs more housing. And the council have gone through the LDP process and allocated 9 new sites. So LSIC, maybe we've talked about it, you need to show, the legal test we're talking about here, of course, is that we need to show that there's more than a trivial connection between the development and the intervention which the proposed contribution both fund. And the council's position quite clearly is this is a package of interventions taken together that must be carried out to ensure there is the capacity levels to allow the new developments to come forward. And that's the link, the impact on the high street.
Okay. Mr. McLeod? Oh, thank you, Mr. McCorrison's going to say something more.
Yeah, thank you, sir. And again, Mr. Alexander sets it out in the appropriate detail. From a planning perspective, and the planning forum have recognised this, you have recognised this yourself, sir, and in fact, the applicant, as opposed to the appellant, the applicant's traffic study confirms the position that you've got a linear high street with very, very limited options for traversing the town without going through the high street. You could, if you were really inclined to do so, you could find a route that would avoid you touching the high street. But it's difficult to conceive that any one of the 563 houses, or the occupiers of those 563 houses, will not have vehicles which will touch the high street. So they have a cumulative impact on the high street, and that impact will be, because of the nature of the layout of the town, I don't think it will be any different depending on where the site is located in relation to the town, because they will all have to travel through that central corridor. So it is that basis that we think it's justified that it is 100% contribution, and that it is effectively a contribution that is split equally across all 563 houses, or whatever the figure happens to be. It's not
maybe a different figure. Some of the industrial sites or windfall sites come into play and may end up in, and it was a bigger figure. It was a different figure with nine sites. I noticed in your submission it was 634 or whatever sites originally, whatever houses, whatever unit number it was, when there was 9 sites. So yeah, that figure is potentially changes, and the repayment arrangements can accommodate that. But it's whatever the right figure is.
Yeah, indeed, and just to pick up on that point that you identify yourself. I mean, we've explained the difference between the 9 sites and the 6 sites. The three of those sites now have consent. Those are sites. So the SISRA report talks about not quite being at the tipping point of my language, not the SISRA's reports language, but that there was some capacity, suggesting there was a nominal capacity remaining. You have to bear in mind that some consents have been granted and houses have been built that will start to take up some of that capacity. I can't quantify that for you. I can't put value on it, but 3 housing sites have been consented since all of this work was done.
I mean, I suspect it's not possible to completely identify with that level of precision, because the world changes, very, very quickly. And the sense I've got from the evidence I've read and heard the past couple of days is whether Linlithgow has not yet got to a tipping point, whether this tips it over, or whether a tipping point at some point in the future, you're into very small margins. And obviously, the very concern the council have had because of areas of restraint and the other evidence that's been led for the council has shown to me that it's in the margins, and where precisely is in those margins is probably not really possible to say, kind of for the reasons that you've just set out. And that it's in that sense that it seems to me there's a difference from Winchborough, where it wasn't really in the margins, and then the 3,400 houses came along and it pushed it right over. And that was, to me, a very obvious tipping point. The question of the tipping point is much more nuanced in the town of Linlithgow, it seems to me. And that makes it quite challenging for everybody involved, for the council and for developers, in deciding what to do and how to construct their applications.
Yeah, and it's if I had that certainty, then certainly my life and the life of the planners who work for West Lothian Council, and indeed everybody else in West Lothian Council, would be a whole load easier. But we don't have that certainty, and the council's approach is to do the best it can for the community. We've got a dichotomy here in some respects in terms of the nuances of planning legislation and interpretation of the circular. We've got 14,500 people who live in the town who have to make do with the circumstances which apply in the town, and the planning forum are much more eloquent in terms of describing what the public view is than I am, and they have done that already. Sir, we to some extent we jumped over question 2.16 on the agenda a wee bit, and I certainly don't want to open up that again. But in terms of NPF4, NPF4 is clear in my view. It's about reclaiming town centres. It's about 20-minute neighbourhoods. It's about town centre first. It's about local living. It's about creating environments in town centres that make them attractive places to live and do business. I think if we can't get a solution to the high street in Linlithgow, then we're going to struggle with the aspirations of NPF4.
Thank you. I'll maybe just move to Mr. McLeod. There's quite a lot in those previous answers, both in relation to my questions to Mr. Alexander, but also what Mr. McCarson has just said. But Mr. McLeod.
Yeah, there was quite a lot. Fortunately, there's not very much that I need to say in response. Mr. McCarson's reference at the end to NPF4 and town centre first and local living and so on has to be considered in the context of the evidence that's already been given, which is the council's view is that Linlithgow town centre has a problem. It has recommendations from an independent consultant on how to solve some of those problems, and the council has chosen not to solve those problems for financial reasons. Now, so far as the question of the tipping point and the nuanced nature of traffic capacity and so on is concerned, Mr. McCarson referred to in one of his answers that the sister report said that there was some capacity, a nominal amount. And I would like to know specifically where Sistra say that, because the evidence that we have, as I understand it in the sister report, is that the town centre was not at saturation levels, and that's as far as they went. They didn't express a view on whether there was a tipping point coming in a traffic capacity sense. And I'd like specific answer, please, on traffic capacity and junction capacity. Where do we find that evidence before the hearing?
I think, in fairness, the reference to tipping point I think Mr. McCarson accepts is one that's developed in the course of this hearing and wasn't one that was used in the sister report. But I think it was the case. It is indeed one of the grounds of appeal that saturation levels had not been reached. But I'll let Mr. McCarson answer on the aspects of that and the consequences of that for the policy development of the council.
Well, yeah, it's a very specific question. Mr. McCarson said that there was the sister report referred to some capacity, a nominal amount, and I would like to understand where that is in the sister report.
Yeah, so happy to deal with that very easily. I suspect that wording doesn't appear in the sister report. It's my interpretation of the position. We've talked at length, sir, about whether we've reached the tipping point or not. I think there's a recognition that we may be over it. We may be approaching it. That there was some capacity. My position is that some, if not all of that capacity, will have been taken up by the sites which have been consented in the interim period.
Okay, can I ask a supplementary question, please, sir? What is the methodology for determining when the tipping point has been reached? What are we talking about tipping? Is it junction capacity? Is it link capacity? What is the methodology, and where is the evidence that shows whether we are or are approaching the tipping point, whatever that may be?
I think, sir, you've answered that question for Mr. McLeod. The term tipping point has appeared in no documentation before the hearing. It's a position which has established. I think, sir, with respect, you may have been the first person to coin that phrase. So clearly, in response to Mr. McLeod's question, that there is no assessment of what that tipping point is. But what I think there is a recognition is that we are someplace close to a tipping point, if that is an appropriate description.
But a tipping point in what sense? Again, are we talking about junction capacity, link capacity, air quality? What is tipping?
The environmental capacity of the high street.
So air quality.
I've explained previously that the environmental capacity of the high street has two elements, traffic capacity and air quality.
Again, sir, I'm sorry, this is turning into a bit of a discussion, and I appreciate that's not what should be happening during the hearing. Let me put it to you as a statement, and then you can ask Mr. McCorson if he wants to respond to it. So, I am not aware of any criteria as to what the environmental capacity of a high street is, how one would measure it, how one would determine whether it's acceptable, and how one would determine whether an amount of traffic would tip that environmental capacity from, I don't know, good to bad, or what the criteria is. So could somebody please assist me, because I would like to understand what methodology should be considered when trying to determine if an environmental tipping point has been reached.
I don't know for the council, either Mr. Alexander or Mr. McCorson, what's the comment on that? Victoria Mungall's got her hand up, so she would have something to say.
Yeah, so I'm happy to give a response, and then Ms. Mungall will no doubt wish to add to that. The environmental capacity of the high street was a term coined in the 1984 Linlithgow local plan, which was the first one that introduced the area of restraint policy. So for a definition, Mr. MacLeod could go back to that document. In terms of the council moving from that position, the position of restraint, it established that there could be no net detriment to the position on the high street. So anything that creates detriment is the tipping point for me in terms of council policy, and this is set out in the local development plan. So the definition is, in my view, where something results in net detriment, it has tipped the balance.
Ms. Mungall?
Thank you, sir. I think Dr. Kelly touched on it earlier when he noted the public commentary on that we are at tipping point. And I think given the figures that I mentioned this morning, it's important to note that from the figures that we've got in Table 10 and Table 11 in the SISTRA report, we're not talking about a 2 or a 3% traffic increase. The overall traffic increase, once all the developments have taken place, is 57%. So it's a significant higher number of traffic on the network than we currently have at the moment. And it's already been explained that there is an issue.
Where's that 57% figure from?
That 57% figure you would get from the table number 7.
Table 7, thank you. Okay, and Dr. Kelly has got his hand up as well. Okay.
Thank you. I think the point I was going to make has already been made by the previous speaker, but what I was going to say was that in the SISTRA report, it does say that capacity is reached when traffic has difficulty to join, and the length of the actual wait. The current situation with the high street is that any traffic coming down Blackness Road, particularly in the evening rush hour, is often queued back beyond Springfield Road, and that's probably an unreasonable length of wait to join the roundabout. The length of wait on the actual high street itself, as what I mentioned previously, it can easily take 10 minutes to go from one end to the other. And as the SISTRA report models, you're likely to stop at least 4 times, which is an issue that's related to air quality. Thanks.
Okay, thank you. Now, I don't know if there's any further points that Mr. MacLeod wants to make in relation to that sequence of questions. I think we've.
I'm afraid there is, sir. So Mr. Snedden has one point, and then I've got one final point to come back on a slightly different issue that I think Mr. Alexander raised in the context of ELSIC.
I just wanted to mention, sir, and really in relation to the Dr. Kelly's point about stopping 4 times. I mean, that, to my mind, that's not really unusual in Town High Street. But quite often, one of the reasons that you might stop would be if there was pedestrians crossing the road. For example, a zebra crossing, in the case of Linlithgow, a courtesy crossing, or a signalised crossing. And I just wanted to draw attention to 412 of the sister report, where they say there are currently no zebra or signalised crossings on Highport or High Street. And then in 413, they say the close by pedestrian crossing on High Street. And in 411, as well as from the signalised pedestrian crossing on High Street. Now, read together, I can't have any confidence that they know how many crossings there are, where they are, or indeed what impact they might have in the modelling and how many times people might stop at them.
Mr. MacLeod?
Yeah, the final point was in relation to ELSIC, and is a slightly different point to what Mr. Alexander was talking about in the context of the legal judgment in ELSIC. It's back to the point about interpretation of policy, and we looked at what Lord Hodge had said earlier on today, and we looked at what the circular had said. But what Lord Hodge said is that the pooling of fixed per unit contributions towards the funding of infrastructure interventions, which include many on which a particular development's impact is minimal, does not meet the criterion in the circular that the obligation is fairly and reasonably related in scale and kind to the proposed development. So in basic terms, a per unit contribution is not appropriate in a situation where a development's impact is minimal. Now, so far as the impact on air quality is concerned, the evidence that you've heard this afternoon from Mr. Carmichael is that this development's impact will be very minute, a very insignificant impact on air quality. And that is an important concession from the Council when it comes to the issue regarding air quality and the need for this development to contribute on the basis sought by the Council, which is an equal per unit basis compared to every other development in the settlement.
Thank you. Now I've got Mr. Nichols' hand up, I think.
Yes, sir. It was regarding the comments raised about the question to do with pedestrian crossings on the high street. The reference was to the sister report, paragraph 4.1.2. That's actually under the section headed the Blackness Road Highport High Street Junction, which is the mitigation, because as we've said, there was two sites within the high street that required mitigation, and the sister report has as far as the report went, chose to come up with a mitigation of the signalisation of the junction. But the existing situation is that at the junction of the roundabout at the Blackness Road Highport High Street Junction, there is actually no pedestrian crossings at the moment, or zebra crossings, and obviously there's a clear pedestrian demand trying to get across the school, the crossing there. And for the schools, we have two school crossing patrollers that are used to get the kids across the roundabout there at the moment. That's what this relates to. It relates to the actual junction, not to the actual high street length.
Okay, thank you. Right. Just looking round. Anything? If we has anything further. I suspect there's probably not much more we can take this just now for today's hearing. I was going to actually just give Dr. Kelly an opportunity to see if he wants to say anything just before we close the hearing today, and then we can talk about timings for closing submissions and the like. But Dr. Kelly, I don't feel obliged to say something if there's nothing new that you want to say. But I just wanted to bring you in because you've been very helpful. In dotting in at appropriate times and helping me out, but I just wondered whether there's anything you want to say just before we close the hearing this afternoon.
I'd appreciate the opportunity to just say a few final words. First of all, we've talked a bit about traffic management and the issues contained around traffic management, which I've said before were adequately described in 1992 in the Halco-Fox report. I do not believe that the traffic management mitigations, helpful though they would be, are going to resolve the problem of additional traffic in the high street caused by new development. We have a number of geographic issues, such as the low bridge under the canal and the railway coming into Lindiscoe that prevents double-deck buses accessing the town from the east. We also have very narrow canal bridge at Mance Road, which has been the subject of discussions at a previous appeal. And if you can bear with me, I'd just like to read the comment from the reporter, Trevor Croft, who on the 14th of May said, it was acknowledged during the discussion that there are a number of potential housing development sites around the eastern and southeastern sides of Lindiscoe. Currently, any development is limited by the difficult access into the town. To develop these sites, potential would first need a full assessment of the traffic requirements of any development, possibly requiring a new access road around the eastern side of the town that would effectively form an eastern bypass. That seemed to us to be a very sensible suggestion. It's one which is going to be incorporated into our local place plan that will go forward to the council for the next development plan. The issue is that there's quite a number of infrastructure changes that could make the high street possible in the event that we had more development. And as a group, the community is not against further development. In fact, the plan for the future that Mr. McCarson referred to and incorporated into the papers of 2015, I think was seeking over 800 new houses, so that we did have capacity for young people to actually stay in the town, which they currently have difficulty with. So the slips are only one option of what is quite a complex traffic problem. And the traffic problem has never, ever properly been accurately modelled. And I think that is the start. If we could start from a position where we take the infrastructure that's required for the development of this and subsequent sites, then we might be able to get to a point where we're accommodating more people and allowing the high street to free flow, which has got to be the primary objective. It's certainly the one that's required by anybody that you ask in Lindiscoe. Thank you.
Thank you. Okay, right. I said at the start of yesterday morning that I wouldn't be expecting closing submissions from the principal parties, and that's obviously remains the position just now. I guess my question, as lawyers in particular, reflecting on the last couple of days, for closing submissions, the question is how long would parties require in order to make closing submissions? Obviously, I don't need to tell anybody on the legal side of things, but Dr. Kelly, if he's keen to make closing submissions, just to remind parties that closing submissions will not contain any new evidence. It'll be a summary, a summation of the cases of the respective parties, whether based on documents, earlier written statements, or evidence heard today, but nothing new. I would also say that whatever date that we determine is appropriate for those submissions, you should submit them to my case officer, Borag Smith. But unusually, compared to most documents, I tend to ask people not to copy them to other parties. We will do the circulation to other parties once we receive them, so that if anybody is submitting a statement ahead of anybody else, then no one else gains an advantage by seeing the closing statements of others. So if you submit them just to the case officers, and once everybody's closing submissions are in, we'll do the circulation for all of that. But the question, I guess, is that matter of duration. And Dr. Kelly's got his hand up again. I don't know if you want to say something about closing submissions before I move on.
Yeah, just make one point as well. I apologise for missing out. The point I'm going to make at the very end of what I was saying was that, of course, the importance is to make sure that all the options that we look at are compliant with Circular 3/2012, and that's a vital point. On the subject of submission, we have a planning forum meeting on the afternoon of the 28th of September, where I'll be reporting back.
Yeah.
I would very much appreciate time after that meeting to write the final submission.
Okay. Well, it's very helpful to have that intervention. I'll ask Mr. MacLeod first of all, then Ms. Foy and Mr. Alexander, what the position is as far as the council are concerned.
I have to say, sir, I'd anticipated that in what I understood to be the usual way with appeals, the planning authority would submit its closing submission first. The appellant would be given a short period of time to respond to that. The convention, as I understand it, is that the appellant usually has the last word when it comes to these matters. Now, so far as timing is concerned, I wouldn't need more than I mean, my intention would be to prepare the closing submission fairly soon anyway, but I wouldn't need more than a couple of days, I suspect, after the council had submitted its closing submission in order to provide you with a composite one that contained our submission and our response to that.
Well, I'd be happy with that if the council are happy with that. Obviously, there's different practices apply in trying to secure fairness in all circumstances, but I'm going to move to Ms. Foy and Mr. Alexander for any thoughts of how they would intend to proceed, mindful of what Dr. Kelly said, and a question of how long it's likely to be needed to give you a reasonable opportunity to gather your thoughts.
Yeah, thank you, sir. I suppose the sequence would be ultimately a matter for you, so I'll leave that with you, how you want to receive the closing submissions. I certainly would have no objection to your idea of submitting them individually, so no one has prior warning, and then we have a grand reveal after everyone's submitted, but that's up to you. In terms of timing, it would be very helpful, certainly for me personally, if we could perhaps have slightly longer than the intended week, but we will always work with you on timeframes. I'm looking at my diary and I wonder if the 4th of October would perhaps assist Dr. Kelly too. That would be just under 2 weeks. But as I say, we can work to what timeframes you would prefer ultimately.
Yeah. I mean, I have no particular strong feelings as to the sort of order of things. If parties would be content to work to that 4th of October deadline, that would apply to Dr. Kelly as well. So we would that give him enough time after the meeting of the next forum, and then to give that opportunity to the appellants for what, 2 days after that, Mr. MacLeod?
Yes, so that would be fine from my perspective.
I close at each of those days, just to be clear as to when anything up until whatever time on the close on those respective dates.
And I suppose if you were minded to adopt my suggestion, could I then also suggest that the appropriate thing to do would be for the council and Dr. Kelly, although I suspect I'm not going to take very much issue with anything Dr. Kelly has said. I think a lot of what he said chimes with the appellant's views. But so far as the council is concerned, if they could simply send the submissions direct to us to avoid any time lag in case they're coming out of time and out of working hours and the DPA is not around and so on.
Okay, fine. Okay, I'll draw something together up with that timetable on that basis and get that issued ideally in the course of tomorrow. Okay, well, thank you all for your contributions to this issue, and we await closing submissions, and then I'll reflect thereafter. So I'll just bring the hearing now to a close, and thank you all again.
Thank you.